Banerjee and the Learned Advocate General, the matter was fixed on the 23rd of June at 12:30 p.m. for fixing of a date. Well, I believe due to some error, the June has become July in the order, Lordship.
No, Milord, we have heard, Milord, it was 23rd July.
23rd June, Lordship. That was agreed yesterday, only for the purpose of fixing of a date. Well, we've checked the.
It was July, Milord. We have heard, Milord.
We checked the YouTube recording as well, Lordship.
What you are doing? Not a single order you are having any without any correction. Status in 23rd June.
Lordship. Just to point out, Lordship, because it's there in the order.
Let us not quarrel on dates, Milord. But only, Milord, one thing that I must inform, Milord. But I have made my inquiries yesterday after the matter was over. But what was informed to the court was not correct.
That's why I have not taken anything on record. Whatever the Chief Justice will decide, that will be
grateful, Lordship.
Or even I am telling if the both advocates say, I will release the matter. There is no.
Let us come back on Monday, Lordship.
May I suggest this, Milord, as since it has fallen from the court, let the matter be directed to appear whichever day your Lordship considers. Let the file be sent to the.
Kindly, Lordship, take it up. Kindly, Lordship.
The Chief will call the file. I can't.
Because, if the matter is retained in the list, Milord, possibly, Milord, they are not requisition.
Malad kindly keeps it on Monday, Lordship. We'll come and make our submission. Malad, Mr. Banerjee is not there, Malad.
I'm not asking. Either the court releases it, then Milord, the file automatically goes. Kindly do not do that. I'm not praying that also. Let the matter
come on 23rd June.
Grateful, Lordship. Grateful, Lordship.
So opening for the petitioner, so opening for the respondent. The counsel for the respondent has mentioned the matter and submits that the court has fixed the matter on 23rd of June 2025, but inadvertently in the order, the date is recorded as 23rd July 2025. In view of the above, in the order dated 19 June 2025, the date shall be read as 23rd June 2025 instead of 23rd July 2025.
Grateful, my lord. Grateful.
Yes.
May I have your lordship's leave to mention one matter? This is a company petition, your lordship. I am just praying for inclusion in the list, your lordship.
Company, but why you are not mentioning on Wednesday at 2 p.m.?
Lordship.
Thank you.
Grateful, your lordship.
Yes.
Respondent.
Your Lordship, I am for the plaintiff petitioner, Your Lordship. Today there was a direction for filing of report, Your Lordship. The plaintiff's first witness action has been concluded. The second witness has a bereavement. Already a date has been fixed on 10 July by the commissioner for tendering his evidence. Lordship, in this matter, the defendant was not appearing and it was and a report was sought for from the register whether this is an this will be marked ex parte or not. If Your Lordship finds that order. Yes, Your Lordship. The order is dated 19 November 2024. The next page number 2, sir. As directed, fifth line from the top, as directed in terms of the order dated 30th January, London Register Ordinal said shall appoint. Sorry. Yes.
Whether the defendant is appearing with the commissioner?
No.
Notice was issued. Examination of the witness.
Yes, Your
to the defendant.
Yes, intimation was given. The defendant did not appear. In fact, Your Lordship, the commissioner is here.
I am the commissioner. Initially, the defendant used to, but thereafter, Your Lordship would also see from the other orders that the defendant had stopped appearing. And this matter related to the other matter where Your Lordship was pleased to close the defendant's evidence because they were playing fast and loose with the court. So, I do not know. And the witness action of the first witness of the plaintiff is There are two plaintiffs.
There's no order of undefended suit,
Your Lordship, they did not appear and
but there is no order. Okay, let the report be submitted. How many witnesses you are having further?
Two. First has been concluded. The second is scheduled on 10th July.
Going on.
Your Lordship, since the
Second
witness is
witness,
not been
witness-
cross-examined, it will be concluded in 1 day only.
Lordship, ma'am, on behalf of the defendant, we have received the brief yesterday evening. So I am praying for accommodation to file the wakalatnama. We have not yet been provided with any instructions regarding what to do.
It is going on undefended suit. Going on undefended. Defendants are not appearing.
Your Lordship, apologies for the. It's an order dated 29 January 2025.
29 January.
Yes. Apologies, Your
25.
Lordship. Yes. Extension of the third line. The second line, none appears for the defendant. Extension of time is paid for, time is extended. And the registered audience shall furnish a report as to whether the suit is undefended or what. This was because the defendant were not appearing in the suit for quite some time.
So that's why where is the order of undefended? There's no order of undefended. Kya bola? So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff submit that. Plaintiff witness number one. Witness number one was examined and cross-examined also.
The defendant did not appear.
Commission and the examination of second witness is going on, or you start?
It will start on 10 July, Your Lordship, since he is not been cross-examined.
Second witness of the plaintiff will be started on 10th of July 2025 before the commissioner. And as such, the counsel for the plaintiff prays for extension of time to file report by the commissioner. So suffering for the defendant and submit that he has instruction to appear on behalf of the defendant and to file wakalatnama. This court find that for the last 1 year, since the August 2023, the defendant is not appearing in the matter. 2023, defendant is not appearing in the matter, and the plaintiff's witness number one also examined and none appears on behalf of the defendant. Thus, the advocate appearing for the defendant is directed to go through the record and to take appropriate steps, if any. But at this stage, it is not possible for this court to allow the advocate to file wakalatnama in the matter.
An officer of the court, may I make one humble submission? But in the other suit also, the a group company of the defendant had not appeared. Witness action was completed. Thereafter, did not cross-examine. An application was filed for recalling of the closure. Then it was reopened to right to cross-examine. So this is dragging for 6.
That's why you're not allowed. I am not allowed, but because the order says something else, madam. You take.
Your Lordship, this is the third set of advocates representing the defendant.
The commission is directed to file the report by 26th of August 2020.
Great.
This is the matter on 26th August 2020. Yes.
May it please, Your Lordship. So this is for extension of time, my Lord, for the mandate of the commissioner. My Lord, it was last extended on 17th of March 2025. My Lord, there was a direction by Your Lordship that the report would be filed by 20th of June. Hence, we mentioned the matter yesterday. My Lord, the witness action is still ongoing. Your Lordship will find from the second page, first line of Your Lordship's order, there's 6 witnesses, my Lord. So it's, my Lord, 3
How
witnesses.
many witnesses have been examined?
3.
The
third, my Lord, is ongoing. There are 3 more, my Lord. I'm only praying for my Lord.
I'm for the defendant, Your Lordship.
Then you will not use evidence.
Lordship.
You will also adduce evidence.
Lord, our witness is going on, Your Lordship.
Their witness action is ongoing, Lord. Our witness action is over.
You will adduce 6 witnesses.
6 witnesses, my Lord. Insurance claim, my Lord. Fire insurance.
My Lord, because the other duties are the forensic experts that given the report.
You know, the number of witnesses have increased after the first cross-examination. So, my lord.
Sense opening for the plaintiff. Sense opening for the defendant. The matter is fixed today for filing report by the commissioner, but the learned counsel for the party submit that examination of the defendant witness is going on, and as such, they prayed for extension of time to file report by the commissioner. In view of the submission made by the counsel for the parties, time to file report by the commissioner is extended. How much time? 4 weeks. Is
Lord,
extended.
may I pray for 3 months so that we don't have to trouble your lordship, my lord?
But we have 3 more witnesses, your lordship.
There are 3 more
They will
witnesses
coming
lord,
from
after
the
this.
outside, your lordship.
Till 24th of September
24th of September. I'm very deeply obliged.
Let the matter appear on 24th September filing by the commission.
Deeply obliged, my lord.
Grateful, my lord.
Lordship, I am appearing for the plaintiff. Your Lordship, I am being led by Miss Priyanka Agarwal. Due to some personal difficulty, she is unable to come today, Lordship. I am just praying for not today, Your Lordship.
Why? What is the suit for?
Lordship, goods and services, goods sold.
Why clause 12?
Lordship,
Why clause
Lordship,
12?
part cause of action has arisen here. The plaintiff has supplied the goods from the 1 minute, Your Lordship. The Lordship, the plaintiff has supplied goods from within this jurisdiction, and the defendant is outside jurisdiction, Your Lordship.
When the last payment was made?
Lordship, a check was issued by the defendant on Your Lordship 25th of June 2024. Lordship, the last payment was made by the defendant on Your Lordship May 2024. Lordship, thereafter, before that, prior check was issued on 20th April. Your Lordship, defendant issued 2 checks on 20th April and 25th June.
Sense opening for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 59,13,020, along with interest at the rate of 9% per annum. 9% per annum. Full stop. Counsel for the plaintiff submitted. The plaintiff is within the jurisdiction of this court, and the defendant is outside the jurisdiction of this court. And part cause of action arose within the jurisdiction of this court, and part cause of action arose outside the jurisdiction of the court. Accordingly, the plaintiff prays for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the defendant and the plaintiff is within the jurisdiction of this court, and the defendant is outside the jurisdiction of this court, and part cause of action arose within jurisdiction, and part cause of action outside the jurisdiction. Where is the pre-mediation report?
Lordship.
The plaintiff has also initiated pre-mediation process before filing the instant suit, and non-starter report has been filed. Considering the above, this leave under clause 12 of the latest patent is granted, subject to scrutiny by the department.
Lordship, a non-starter report has been issued by the Your Lordship,
And actor P.
Lordship. Lordship.
But I am appealing for the alleged contemners. Lord, this contempt petition was filed, my lord, pursuant to your lordship's direction, my lord, where we suffered an order, my lord, wherein we were supposed to furnish security to the tune of 40 lakhs. Plus 27 lakhs was furnished, 13 lakhs was left.
13 lakhs.
Lord, your lordships will see the last order. There was an office report which was sought. Lord, the check which was submitted for the balance 13 lakhs, my lord, that was returned. Subsequent to that, my lord, we have submitted a fresh demand notice and the same was submitted on 22nd of May 2025. My lord, may I just hand over a copy, my lord, which has been received by the registrar original site. My lord, with this, my lord, the entire order has now been complied with, my lord. Nothing really remains in the contempt petition. I do not
My
know.
lord, I appear for the petitioner, my lord. My lord, I beg my lord's leave to appear virtually. My lord, for a copy of whatever is being handed up to my lord be handed over. I request Mr. Shortkar. My lord, to our knowledge, the check hasn't been honored. So, my lord, will kindly allow us to go through whatever is being submitted today. We are not aware.
I'll hand it over to my learned friend, my lord. It's a demand draft, my lord. I'll hand over a copy which we have submitted.
This demand draft has been encashed or not? What? What? कहाँ है? ऐसे ऐसे रजिस्टर लोगों को पोस्टिंग करेंगे ऐसे ही तो होगा.
My lord, will kindly. May I make just one submission, my lord? The order is of 30th August 2024. Today we are in May 2025. June 2025, my lord. Still, it's not clear whether they've complied with the order. My lord, let a fresh report of the registrar be called for, my lord, whether the order has been complied at least, and thereafter we'll make submissions, my lord.
So supreme for the decree holder, so supreme for the judgment debtor. Judgment, the registrar original side has filed a report dated 23rd May 2025, wherein it reveals that initially the defendant and the judgment debtor has issued a check of rupees 13 lakh, being check number 700496 dated 4th May 2025, drawn on Punjab National Bank Varanasi, Sigra within bracket Varanasi branch, Uttar Pradesh, to the
This report once and be
office of the
sure.
registrar on 5/5/2025. It is found that the said check issued by the judgment debtor was returned with the endorsement advice not received. Advice not received. Subsequently, the learned counsel appearing for the judgment debtor had submitted a fresh demand draft dated 20th May 2025, being number 404027. Dated 15th May 2025 for a sum of rupees 13 lakhs, drawn on Punjab National Bank Varanasi, Sigra within bracket Varanasi branch, Uttar Pradesh. Before the registrar, original side of this court. Consider the submission. Consider the report of the registrar original side, registrar original side directed to encase the said demand draft and to invest the said amount of rupees 13 lakhs in a fixed. The execution or contempt? What is this?
That's a contempt petition, my lord, against
Contempt
order.
petition.
So ऊपर ना petitioner contempt करो, not decree holder मत करो. Petitioner and contemptors. क्या बोला? Directed to encase the said amount and to invest the said amount of 13 lakh in the interest bearing fixed deposit and to submit the report before this court on 17th of July 2025.
Deeply obliged.
Obliged, my lord.
We copy it.
My application.
I'm opposing this.
Yes.
Lordship, it's an application for modification of your lordship's order dated 6th of January 25. The order is at page 30.
Order GA number?
GA number 1 of 25.
Yes. Page?
Page 30, Lordship.
The relevant portion, Lordship, starts from page 31 at the bottom. May I read, Lordship? May I read, Lordship, page 31 at the bottom. Considering the submission made by counsel for the plaintiff, the District Collector Tirupati and District Collector Tiruvallur are directed to direct the concerned authorities, Tehsildar or Sub-Registrar or any competent authority not to register any kind of deeds or things with respect of the aforesaid landed property in respect of description which has been forwarded by the district collectors before this court and to submit the report on the next date filed. Lordship, on that date, learned collector has filed a report. Lordship would take the report which is at page 197.
Yes.
Lordship would take the report page 197, paragraph number 8, Lordship. May I read, Lordship, paragraph 8?
Yes.
It is submitted that the Tehsildar of Uttikotai Taluk in his letter dated 20th December 24, White such and such has provided details of the properties belonging to Mr. D. Solapan, son of Mr. Devan, within the jurisdiction of Uttikotai Taluk, which is the residential taluk of the contender number 8, as follows. Lordship would see there are description of property from serial number 1 to 25. Lordship, so far the properties mentioned from serial number 17 to 25 is concerned. Lordship, I have no objection with regard to the orders passed by your Lordship. Your Lordship was pleased to direct the collector not to do registry of any kind of deeds with regard to the description. तो आगे ही बोले दाओ ना agree करते तो. Lordship, they agree. They are agreeing for the modification. No, they should have said in the beginning. Anyways, Lordship.
My learned senior friend has just now submitted that she is not objecting
हाँ,
to 17 to 25 being there,
Lordship.
but 1 to 16 being the inherited properties. That is
Lordship.
why she is. We do not object.
Lordship.
Just to cut short the matter.
Lordship.
Thank you.
Grateful. Paragraph 13, Lordship, I have given the details, page 21 at paragraph 13, Lordship. If save and accept could be incorporated, Lordship, it would save my purpose. Save and accept the property mentioned in serial number 1 to 16.
So and so offering for the petitioner. So and so offering for the alleged content number.
This is an application by 8.
Offering for the content number 8.
Lordship, I am also appearing on behalf of contender numbers 1, 2, and 4. But it is her application, so I have nothing more to say.
Also offering for the content number 1, 2, and 4. Contempt number 5. Contempt number 8 has filed the present application GA1. GA1.
GA1.
1 of 2025 in CC 26 of 2023. Praying for modification of the order passed. Modification of the order passed by this court dated 6th January 2025 in CC 26 of 2023. Counsel for the petitioners, counsel for the alleged contempt number 8 submit that by an order dated 26th of January 2025, this court directed the district collector from Tirupati and district collector Tiruvallur and the concerned authorities Tiruvallur to direct the Tehsildar or sub-registrar or any competent authority not to register any kind of deeds or things with respect of the landed properties in respect of the description which has been forwarded by the district collector before this court and to submit report on the next date fix. Police stop. Counsel for the alleged content number 8 draw the attention of this court to the report of the district collector dated. What is the date of the
Date of the affidavit, Lordship.
district collector's report
Lordship.
dated 3rd January 2025. 5. wherein in paragraph 8, the description of the property has been mentioned. The description of the property are as follows. ये वाला है पेज 197 का, इसको लेकर के यहाँ तक, ठीक है, कर दे, पेस्ट कर दे, कॉपी कर दे. Counsel for the content number 8 submit that the property number 1 to 16 are the ancestor property of the content number 8, and as such, due to the order passed by this court dated 6th January 2025, the content number 8 is facing difficulties, and the press for modifying the order by deleting the said property, that is item number serial number 1 to 16 from the order dated 6th January 2025. Counsel for the, can concession be recorded?
Yes, but only on one submission, that because contemnant numbers 1, 2, and 4
Already.
have now paid a part and also given some of their properties. That is why we are conceding.
Counsel for the petitioner submitted that the property mentioned in serial number 1 to 70,
1 to 16.
1 to 16, 16 karna. 16 is the ancestor property of the defendant, contender number 8, and the contender number 1 to 4 have also made part payment in terms of the order passed by this court, and the detailed report of the property of the contenders number 1, 2, and 4 have already been brought before this court by the concerned authorities, and this court has passed appropriate order with respect of the properties of the contender number 1 to 4, 1, 2, and 4. Consider the submission made by the counsel for the respective parties for the materials on record. The order dated 6th January 2024 is modified, 2025 is modified to the extent that the properties mentioned in the report of the district collector from serial number 1 to 16 will not be affected with the order dated 6th January 2025, and the contender number 8 is free to deal with the properties mentioned in serial number 1 to 16 of the report of the
Lordship, let
district
collector be directed to act accordingly, because he has put notice board, Lordship, so far my native property is concerned.
The petitioner is at the content number 8 is liberty to inform this order to the concerned authorities, and the concerned authorities shall act according to this order.
Very well, Lordship. Grateful, Lordship.
Only one clarification. Though it is a surplusage, but may I humbly say that, however, this order will not prevent the collector from exercising the right in terms of that order for serial number 17 to 25. I know it's a surplusage.
It is not required. It is not required. Now they have got 2 crores of rupees. Only 2 crores and odd remains. And the property details is also there of Jairam Chaudhary. Grateful, Lordship.
GA number is disposed of.
Grateful.
Grateful.
Well, at 8 to 12, I am appearing for the award debtor. Well, in this matter,
8 to 12.
8 to 12. May I just indicate what happened on the last occasion, my lord? On the last day, my lord had directed the judgment debtor, my lord, to make payment of the awarded sum, my lord. My lord, they, my lord, are not in a position to pay, my lord. The affidavit of assets, my lord, I have prepared, my lord. But they'll face the rigors of law. He'll present himself for examination, my lord, as a judgment debtor, my lord. My lord, I have already served my lord in friend with the judgment, with my affidavit of assets, my lord, the supplemental one, because my lord had directed on the last occasion that I should file my balance sheet for the last 2 financial years, my lord. This is, my lord, I've prepared. I'm served also, my lord. So, my lord, can fix a date for his examination, my lord.
In all cases?
Yes, my lord.
8 to?
8 to 12, my lord.
8 to 12, 8, 9, 10, 11, 12. So, instance suffering for the decree holder. So, instance suffering for the judgment debtor. What about the deposit amount of registered by 70?
They are not in a position. The sole judgment debtor company, the company does not have any assets. That's what.
Appearing for the.
He has to examine.
Mr. Subhankar Nag appearing for the.
You are appearing for whom?
I'm for the award holder.
Award holder.
So? What is the submission?
Mr. Subhankar Nag appearing for
Huh?
Mr. Subhankar Nag appearing for
Why
the
are you appearing here?
court number 887, my lord.
Census appearing for the decree holder, census appearing for the judgment debtor. Judgment debtor submits that though this court has passed an order directing the judgment debtors. In each case, what
Yes, madam.
this is a one case.
The separate awards. So same judgment debtor, same award holder, same award debtor, same award holder.
तो amount देख लेना हर केस का. Pass to deposit the amount of rupees 1,26,68,300 before the registrar original side of this court by 17th June 2025. Learned counsel for the judgment debtor submit that the judgment debtor is not having any amount to deposit the same before the registrar original side of this court in terms of the order passed by this court. Accordingly, the judgment debtor has filed affidavit of assets after serving the copy to the learned counsel for the award holder. The award holder. Full stop. Let the affidavit of assets be kept with the record. Full stop.
My lord, the person is physically present in court, my lord. He has come from Rajasthan. Let kindly record that.
Can he be taken into custody?
No, he is not under warrant of arrest. He is voluntarily appeared.
But he has not paid the amount. What can be done?
My lord, he has to, my lord, if he is not paid, he has to undergo, my lord, the procedure, my lord. So, my lord, he is willing to be examined, my lord. My lord, kindly record his appearance today, my lord.
Let the matter.
Mr. Pankaj Jain, my lord.
And so, Mr. Pankaj Jain, the judgment debtor, is appeared in person. Full stop. And he submit that he intend to examine himself in the instant case. In view of the above, let the matter give the date for examination, judgment debtor. Let the matter appear on 22nd July 2025 at 12:30 for
Very well.
examination of
He shall
judgment
present
debtor.
himself. I'm deeply obliged. 22nd July.
ये जो अमाउंट लिखा है ना, अमाउंट चेक कर, इसका जैसा 1 करोड़ बोला, बाकी का चेक करके
8 to 12
8
minutes.
to 12, 8 to separate order.
I'm deeply obliged.
Application for execution. Well, on the last occasion, the judgment debtor has sought time. But what has happened in the meantime, your lordship, they have purportedly filed an application after 1 year under Order 9 Rule 30 for setting aside the decree.
मनु तो शुआ ला ये वाला कल एक ट्रांसफर करने वाला मैटर नहीं रखा क्या? ये आईपी वाला मैटर नहीं रखा?
ना मैं petition है तुम उनके जाओगे judgment.
Yes.
My lord, it's an application for execution, my lord, of a decree dated 10th April 2024, your lordship. Now we have filed 2 applications. One is GA2, which is an application, my lord, for
appearing for
filing
whom?
affidavit of assets. Well, I am for the petitioner, for the award holder, and for personal presence. That is GA2. And my lord, subsequently we have filed a GA3, which is a receiver application. My lord, continuously the judgment debtor was not appearing. On last few occasions they had appeared. On the last occasion, my lord, someone had appeared on behalf of the judgment debtor number 1. And they had sought time for judgment debtor number 2. That is the state of Madhya Pradesh.
No, on the last occasion, the judgment debtor is State Bank of India.
My lord, there are 2 parts of one. There are 2 parts of the decree, my lord. One was to be complied by the State Bank of India, and the other one was on the part of the state of Madhya Pradesh. But as far as the State Bank of India is concerned, they have complied with the decree. They have not discharged the bank guarantee. But the state of Madhya Pradesh will be answering because our claim is basically upon the state of Madhya Pradesh. Your lordship.
My lord, Mr. Advocate General is appearing for the state of Madhya Pradesh in this matter, my lord. On his behalf, I am praying for an accommodation for
On
one.
the last occasion also the
Last
same thing was
occasion they
happened.
paid. On the last
I am
3
for State
occasions
Bank
they
of
are.
India, my lord. As it has been rightly pointed out by the petitioner, we had already complied with the court's order. It has been recorded by Justice Patnaik as well.
So, on the last occasion also the same thing was happened.
On last occasion, my lord, state of Madhya Pradesh paid for an accommodation, but wrongly it has been recorded against judgment debtor 1, that is State Bank of India's name. And
So?
it appears from the judgment that there is only one
What is the decree?
judgment.
And it's a money decree of an amount of rupees 1 crore 15
So
lakh.
why you are filing again and one or the another application?
Well,
Once
the
you file
first
the, once
application,
you file the execution case, then why you are filing application and applications?
yeah, your lordship, just
You persons are not interested to proceed with the matter.
Yes,
you
your
you
lordship.
persons are interested to file one or another application.
the first
Once the execution case has been filed, what is the necessary for filing all other applications?
Well, the state of Madhya Pradesh was not appearing. Well,
Not appearing, the court will take the action. So you're filing application, you're creating your bills.
Lordship, if your Lordship kindly allows, your Lordship, I am for the decree holder.
I am not allowing this type of the practice. Once the execution case has been filed, let the execution case proceed. Receiver, this, that.
May I just?
That's why none of the cases are going to be disposed of.
Lordship, if your Lordship kindly allows your Lordship, once your Lordship, to make my submissions.
Yes.
Lordship, what happens, your Lordship, in execution, in tabular statement, we give all the prayers. Now, your Lordship, whenever your Lordship in execution, we require certain orders. Your Lordship, it's always, your Lordship, I beg to only state, your Lordship, only for the implementation of the order we filed application, not regarding our, your Lordship, professional bills. If your Lordship kindly sees, your Lordship, the tabular statements, all prayers, your Lordship, we have included it. But your Lordship, they were not appearing, and we require certain more prayers. That's the only reason, your Lordship, we have done. If your Lordship kindly sees the execution application, all prayers we have given.
Where is the tabular statement?
If your Lordship kindly sees the tabular statement once. Lordship kindly sees prayer A, your Lordship, is for the payment of the money. Prayer B, your Lordship, is for the injunction. Prayer C, your Lordship, is for the attachment.
Correct.
And your Lordship, prayer D, your Lordship, is for the direction upon the principal secretary to your Lordship to file the affidavit of assets. Now, why we have done, your Lordship, only on the reasons that this particular prayers, your Lordship, they were not implementing. So that's why, your Lordship, we filed this first application for attachment of the bank account, which we obtained. But thereafter, your Lordship, regarding the disbursement of the money, your Lordship, we filed the second application. And when we actually come before your Lordship, when we file, your Lordship, the GA number 2, at that point of time, your Lordship, Lordship was of the view that unless and until we file an application for appointment of receiver over their offices, they'll not come. The moment we filed it, your Lordship, they have come. And now you're yes, your Lordship. Lordship, that is GA3. Lordship, kindly take GA3. Kindly take GA3.
Correct.
The first layer, your Lordship, is the appointment of a receiver to take physical possession of the office of the judgment debtor number 2. And your Lordship, the prayer B is, your Lordship, to take the physical possession of the movable and immovable. If they pay the money, your Lordship, the entire problem will be sorted out. But your Lordship, only because, your Lordship, time to time we require the reliefs, your Lordship, so that they can pay the money, we have taken out this application, your Lordship.
Okay, I'm passing an order appointing a receiver.
Yes, sir. I'm grateful. I'm grateful, your Lordship.
But kindly allow an accommodation for bond.
The court will not showcase. Execution proceedings. Your government is not having the amount in the bank account, which was furnished by the petitioner. Now the petitioner filed an application for attachment of the office. Now we have come with the Advocate General. And that too is not appearing. Let the office be attached. And if you want the offices to be released, then pay the amount, then office will be released.
Kindly,
I know how the execution is to be carried out of the decree.
1 day accommodation.
State of Madhya Pradesh is not having any amount in the account of the government. It is impossible.
Kindly allow.
What allow?
1 day's accommodation.
Sorry. So and so suffering for the decree holder. So and so suffering for the State Bank of India, and so and so suffering for the state of Madhya Pradesh, the judgment debtor. Police. The petitioner, the decree holder has filed the execution proceeding, execution case, saying for execution of the order, execution of judgment and decree passed by this court dated Where is the date? Which
decree.
order?
The injunction order.
Execution decree.
Decree, my lord, it's of 10th April 2024.
Where is that?
My lord will find it in the execution application, page 16.
Dated 10th April 2024. Wherein? This court. Wherein this court? Was a decree declaring that the plaintiff do get a decree of rupees 28,33,356 with interest at the rate of 10% per annum from the date of institution of the suit till payment as refunded of money, and the plaintiff do get a decree of rupees 13,99,950 further on account of loss of profit. This court also injuncted the defendant judgment debtors by way of permanent injunction, invoking or giving any effect to the bank guarantee bearing BG/24/97-98 dated 25th of October 1997, BG 25-97-98 dated 25th of October 1997, and BG/26, 97, dated 25th October 1997. This court also granted decree of cancellation and delivery of the bank guarantee mentioned by the defendant number 1 is directed to cancel and deliver the bank guarantee to the plaintiff. So what about the BG? BG, there is no amount.
The bank guarantee had been with the State Bank of India.
That has been stopped.
The bank guarantee.
After filing of the execution case, the plaintiff has taken appropriate steps. But on that, by which order this is found that there is no amount in the account?
Will kindly take
by which report?
GA2, your lordship.
Yes.
GA2, my lord, page 30. This is being written by the ICICI Bank.
Balance, just show the balance.
The balance is, your lordship will kindly take at the middle of the page, 84,713, your lordship.
Where? How you got this report?
This is pursuant to order passed by the honorable coordinate bench.
In the execution case?
Yes, your lordship.
In the execution case, this court has called for the report from the ICICI Bank with respect of the details and the amount pending in the account number 185705004699 in the name of Dakshin Vanmadal Jila Balaghat Vanapaj Sahakari Sangh Maryadit. ये देख लेना, ये देख के लिखना. Maryadit. The bank account was active, but only an amount of rupees 84,713 is lying in the said account. In the report, the bank has informed this court that the bank has marked the said amount, said account on lien for a total sum of rupees 1, 15, 54, 232. Police stop. Counsel for the plaintiff decree holder submitted as whose account is this?
This is the account of the state, the judgment data number 2, your lord.
It is name of the judgment of 2.
Well, yes, this was provided by the award holder.
But I have for we have filed the review application.
Okay, I am passing an order.
Not only on the ground, your lordship, kindly hear.
No, sir.
Not only, your lordship.
What?
Only your lordship.
What you want to submit, sir?
Submit, my lord, submit.
Once the court is going to pass an order for
No, no, that's fine.
attachment of the
Not attachment, my lordship. Kindly, my lord, what has happened? Kindly, my lord, for the ends of
decree
justice.
has been passed, you have to comply with the decree. That's only.
Decree has been passed, my lord. We are bound. We are bound.
Then,
but my lord, when the decree was passed, whether they have come up because records were not traced out.
What?
That record, my lord, reconstruction record. And what is our documents that was not placed before your lordship?
Yes, you are not contested the suit. You are not contested the court will go to your house.
No,
and
we
take
have
the record.
contested. We have filed. We have filed here.
Have you adduced the evidence?
No,
Yeah.
Decree is there.
Lord,
Have
we
you
have-
filed an application
Lord-
for recalling of the decree?
In application, my lord, all documents we have.
And that the
documents, it has lost from the department.
Maybe.
Maybe.
Today, before the court, there is a decree.
The decree.
The decree has not been set aside by any of the court.
No, that's right.
Neither record.
No appeal filed.
No appeal. That's why no appeal is filed, no review is filed, no recalling application is filed.
Recalling application has been filed.
Where is that?
Not a recalling of
Yes.
decree.
Where is that?
Yes, your lordship, kindly see the number.
Review file.
Kindly see the number.
It's a review application.
Place.
Lord, review application, review number, Lord.
Where is that?
17 of 2025.
Where is that? Today review is appearing. There's no review. You're not mentioned.
Mentioned, Lord, we appear before your lordship.
When? Show the order. Show the order.
Your lordship, kindly see the Lord, we have.
You may be filed. Where is the order? You have mentioned the court has passed an order admitting the review application issuance.
No. We have mentioned for inclusion of the review.
When you mentioned?
Lord, I appeared before your lord.
Before me, you are not appeared in.
Yes, I appeared, Lord. That's why the matter was adjourned.
Show the list. Review application mention हुआ है? नहीं.
That is why adjourned.
Sorry, sir. The total bar is appearing before this court whenever the matter is been.
I am the last person after 38 years.
Maybe 38 years, maybe 40 years.
I will tell
I
lie.
have 3 years only experience in this seat. I know.
No.
Whenever
I know your lordship's experience. I know.
Whenever the matter is mentioned, every day I am taking the mentioning matter. It's been listed.
Lord, it was adjourned, Lord. I appeared, Lord. Hurriedly, I went here. Lord, I came here, and Lord, the matter was adjourned. Lord, we have mentioned, Lord, I cannot, we have no evidence
when
to
you
prove.
mentioned, tell me.
Mentioned,
Okay, you show me the notice.
But it was filed, Lord, your lordship.
Okay, Mister, you show me the letter of motion.
Affirmed on 7th May.
You show me the notice of motion.
কোথায় গেল? এটা নিয়ে আয়।
Where you got the other side, you are mentioning the matter. Show me that.
Your lordship, kindly give me, Lord, because records with Miss Sumita,
Sure,
my junior. And Lord, it was 7th May 2025. I believe file has come before your lordship.
7th May
2025.
So thereafter you not come when the matter is not been listed. Thereafter the matter was taken on 11th June. You are not mentioned. Review application was filed. The matter was taken on 6th of May 2025.
But 11th June, 11th June, I remember I had been here and matter was adjourned. That's why.
But you have not mentioned
Because
your review application is to be listed, sir. The order is there and you are not challenging this order, neither you mention. Please.
Lordship, kindly consider that the construction after, but kindly consider one thing. That the entire records was not found.
Maybe, sir. No. That is your difficulty.
But if your lordship say maybe, Lord, that I have nothing to submit.
Yes, you have nothing to say unless that the court will look into if your order has been set stayed or you have been set aside or recalled. Nothing else.
Then your lordship kindly, Lord, kindly record my submissions.
What?
The records were my submission. Today I am appearing.
Yes.
Record my submission. Yes, Lord.
Have you filed the wakalatnama?
Yes.
Just on the
engagement letter number ko dekho. I have been engaged by the Madhya Pradesh government.
Have you filed the wakalatnama?
But I cannot file my junior file.
Yes, you have filed the wakalatnama.
No, he is not. Somen Chatterjee.
Who has filed the wakalatnama?
Somen Chatterjee.
Show me. Wakalatnama hai, dekho.
The wakalatnama review application থাকলে তবে দেখাবো না কি করে দেখাবো আমি original review application দিলে দেখাবো.
Once they are praying for adjournment on the ground of the AG, when this court has not granted the adjournment, now you are coming on in the mid of the order.
AG is not appearing in this matter.
Just the adjournment has been asked. AG of the Madhya Pradesh?
Oh.
No, there is no wakalatnama.
But wakalatnama with the review application. With the review application, wakalatnama.
in this matter. So you are submitting, you are making submission in the execution proceeding. In the execution proceeding, you file the
And this is
wakalatnama.
Lordship kindly stated. Dekhan to Joseph. Dekhan. When I've been engaged, and this is the wakalat.
Okay, I am not telling you. Show me the wakalatnama.
Yes, the memorandum of review.
Sir, I am not on review. This court is today considering the EC. Show me the wakalatnama in the EC.
Lordship kindly see this. Dekhan to Joseph. This is Xerox. Show me that. It's very unfortunate. And AG bole dichis কেন? AG আছে এখানে?
Yes, what do you want to show from here?
But that is the showman chat is this, and the master in charge. Your Lordship kindly see from the department it was given.
What is
But
this?
all that I am praying, Lord, the record was not found. Learned advocate who appeared earlier for the Madhya Pradesh government, he has not taken steps. However, Lord, when the reconstruction was filed by them, our documents have not been produced before your Lordship. Though it was available.
So
It was available with them.
So you are not appeared.
Yes, that is our wrong. We are tendering unqualified apology for this. But Lord, without considering our documents, that is in the review application.
Sir, I think your misconception. This is a civil suit.
Yes, I know.
Correct.
Yes.
Decree is passed.
My lord.
And this is the execution proceeding.
Execution proceeding.
The execution proceeding, there is no your application. What you are submitting before this
Application
court.
is in your Lordship's court. Review application filed 7th May. Lordship kindly record my submission. Record my submission, then your Lordship kindly pass the order. Pass the order. If our documents are not reconstructed and decree was passed behind that documents, then your Lordship should have taken into consideration that.
Learned Counsel appearing for the state of Madhya Pradesh prays for adjournment on the ground that Advocate General of the Madhya Pradesh is appearing in the matter.
No, my lord, I am not. Your Lordship kindly. Lordship,
When this matter has.
Your Lordship, don't record that. I am not praying that.
When you are not prayed.
But I'm rectifying.
Your back,
I'm rectifying this.
When the
inadvertently, kindly record that.
When this court has refused to grant time, in the meantime, what is your good name, sir?
Mr. Sopur Banerjee, your Lordship has forgotten me.
Learned Advocate had appeared in the mid of the dictation of the order and submits that the plaintiff has obtained the decree by suppressing the document.
And that was wrong submission. Learned AG is not appearing. Lordship kindly record that. But I have never said so. যেগুলো জানিস না সেগুলো বলবি না কে বলেছে
You are not stated. No? You can file an application. You have not stated that AG.
No, he has stated.
Yes, sir. I am asking to one of the advocate. You have not stated before this court the AG is appearing.
Yes.
Tell me.
Yes. But wrongly. I have not instructed him.
This. Submit that. The
আমাকে ওই অ্যাপয়েন্টমেন্ট লেটারটা দেবেন যে এনগেজমেন্টটা দিলাম
the decree holder has obtained the submit that the documents of the judgment debtors are not traceable and they have reconstructed the file and have filed the review application before this court and the review application is pending. And he prays for time. Full stop. Counsel for the judgment debtor that the state of Madhya Pradesh submit that the review submits that he may submit that he is appearing in the matter and Advocate General of the Madhya Pradesh is not appearing in the matter. Considering the above, this court finds that the review application filed by the judgment debtor, that is the state of Madhya Pradesh, is not before this court. Thus, no order can be passed with regard to the review application. No order can be passed with regard to the review application. The learned advocate appearing for the state of Madhya Pradesh has not prayed for any prayed for any time with regard to the execution proceeding. And as such, this court is no other option but to appoint a receiver, for attachment of the
নাম দিয়েছিস আমার
for attachment of
তুমি আসবে না কোন কোর্টে উল্টো পাল্টা বলার জন্য তার নাম দিয়েছিস রিসিপ্টটা দিন তো কেন পাঠাছে কে তুমি যাও প্লিজ বল
attachment of the office of the Chief Conservator of Forest within bracket Balaghat Circle, Senoi Road, before Gara Railway Crossing, Balaghat, Madhya Pradesh, -481001, and the office of the Divisional Forest Officer, South Production, at Senoi Road, Balaghat, near Kalipat, Madhya Pradesh, 481001, by putting the padlock in the said offices and to submit the report before this court. Police stop. The receiver and police stop. So is appointed as a receiver to attach the property as
judgment date true লিখে দেবেন
as mentioned above,
judgment date true লিখে দেবেন
as mentioned above, and to file the report before this court within a period of 2 weeks
Thank you.
from date. Full stop. The receiver is at liberty
7th May review application এখন আসেনি এখানে
before the concerned police authorities, including the superintendent of police of the concerned district, if any restraint, if any of the authority or any person or agents are restrained the receiver to carry out the order passed by this court for attachment of the office of the Chief Conservator of Forest and Divisional Forest Officer in connection with this case. The remuneration of the receiver is fixed rupees 50,000, and the petitioner is the decree holder is directed to pay the said fee of the receiver. Let the report be filed before this court on 2 weeks बोला ना 3 weeks on 17th of July 2025.
So your lordship has recorded that when the reconstruction was filed, our document has not been placed before your lordship.
I have recorded what you submitted.
My lord,
what you have submitted, all the things have been recorded.
but this is very, very important, lord.
Maybe.
That's why we have come before your lordship's review.
Okay.
And lord, may I take back the papers, lord? I have handed over. The 27th May review file, lord, it has now
27th
department.
I think you are not appearing in the original side. There is a provisions. If it is not,
I failed to. I'm not very sorry, my lord. Very sorry to say, your lordship has actually not known to me.
That's why I'm
because the original side, your lordship don't learn me original side. I know.
That's why
I know. Your lordship may be not.
So that's why
constitutional chair.
That's why
But no.
That's why on 27.
Yes, I mentioned, lord. If your lordship's court is inactive, lord, I can't say.
Never
Yes, never mentioned. They can say.
That's why I'm telling you.
They can say never mentioned. I mentioned.
That's why I'm telling you the mentioning notice.
Yes. But your lordship has not given the chance.
What?
To bring the notice.
Okay.
To bring the notice. If your lordship is so adamant to pass the order, lord, I have nothing to say.
Okay.
Yes, very
problem.
nice, lord. Very nice. Thank you. Grateful.
Lord, I am for the degree holder, my lord. But on the last occasion, the records of the execution application was not here, my lord. That's why that matter was adjourned.
Item number
14, my lord.
My counsel, my lord, he has accompanied his wife to hospital, my lord, for post-operation treatment. I'm praying for a possible, not to them.
Record of execution case not placed before this court according to record आया?
Well,
yes.
Here, my lord, the directors were a company and its directors were directed to file their affidavit of assets. My lord, only the company has filed their affidavit of assets.
The directors are not made parties to this suit, my lord.
Yes, my lord. And on the last occasion, they are taking this point that directors are not responsible for that. My lord, with regard to that, I have a judgment that this corporate will can be lifted, my lord. So, my lord, let them, if they, on the personal ground, my lord, I do not object. If it is not today, my lord, I do not object, my lord. But let them file the affidavit of assets. Let the directors of the company file.
The company, my lord, we have filed.
So and suffering for the decree holder, so and suffering for the judgment debtor, as per the prayer made by the counsel for the judgment debtor, the case is adjourned. Let the matter appear on 5th of August 2025.
Very
Good.
For the decree holder, my lord, on the last occasion, our lordship had directed to, my lord, serve upon the award, my lord, the debtor. And, my lord, we have served, and here's the affidavit of service, my lord. The judgment debtor is not appearing still, my lord.
Who is the judgment debtor?
But APL Metals.
Huh?
APL Metals.
APL Metals
Limited. But there was a deposit of 17,67,248 with the, my lord, learned registrar of the original site, which we have obtained. The balance amount, my lord, of 8 lakhs odd on account of interest is still.
What is the total decretal amount?
The decretal sum was 17,24,400 with an interest of 18%. On the, in the last order also, your lordships have mentioned. So 17,24,400 with interest of 18% comes to, my lord, 25,61,324. So, my lord, the balance amount of 8 lakhs odd on account of interest is still outstanding. For that, my lord, I'm praying for injunction on their bank account, my lord. It's mentioned, my lord, in the execution petition itself, my lord. In the tabular statement, your lordships will find.
So they are not appearing. What can be done?
But we have served upon them.
So,
and, my lord, warrant of arrest, your lordships may issue, or, my lord, an injunction on their bank account, which is in the part of the tabular statement, item number Roman 2. Overleaf of the tabular statement, my lord.
Attachment of the following properties.
We have ascertained 3 bank accounts. Also, my lord, 2 properties are there.
So and suffering for the plaintiff and decree holder. None appears on behalf of the judgment debtor. The decree holder filed the affidavit of service showing the notice of the execution proceeding is served, but none appears on behalf of the decree holder and judgment debtor. Full stop. Counsel for the decree holder submitted. This court passed a decree directing a defendant to pay sum of rupees 17,24,400 along with interest at the rate of 18% per annum from 25th of December 2021 till the realization of the said amount. But in spite of the order, in spite of the decree passed by this court, the judgment debtor has not paid the amount. Even after the receipt of the execution proceeding notice, the judgment debtor has not appeared in the matter. Full stop. Not appeared in the matter. Consider the submission made by the counsel for the petitioner as decree holder, as the judgment debtor, in spite of the notice, not appeared in the matter. Prayer in terms of II is II, II and III is granted till the disposal of the present application. Full stop. The judgment debtor is given liberty to file the affidavit of assets within a period of 3 weeks. This order may be communicated to the judgment debtor. Let the matter appear on 30th July 2025.
Grateful, my lord.
I and I of the na tabular statement. Yes, item number.
But this is my application, my lord.
Yes.
For substitution, kindly, my lord, allows me to, my lord, recapitulate in detail because it has been, my lord, argued before your lordship, my lord, almost not a month and a half back, my lord. My lord,
12th June, 12th June was the last day.
no, but we did not argue on that. My lord, your lordship, my lord, kindly takes, my lord, a substitution application where, my lord, we wanted to substitute, my lord, one of the defendant who is a partner of, my lord, the defendant number 1 partnership firm. Now, my lord, defendant number 1 is the, my lord, partnership firm. Defendant numbers 2 and 3 are, my lord, the partners of the partnership firm. Defendant number 3 has, my lord, 3 has, my lord, expired. And, my lord, we are, my lord, proposing to bring in their heirs. Now, my lord, to this, my lord, initially, affidavit was, my lord, called for from, my lord, the appearing defendant number 2. The defendant number 2 in its affidavit said that we are in the process of reconstituting the partnership firm. As soon as the partnership firm is reconstituted, we will tell you the name of the partner. That was the stand taken in the affidavit which was called for. Now, my lord, after, my lord, lapse of time, my lord, the matter was again, my lord, taken up for hearing when, my lord, Mr. Bose had appeared, Learned Mr. Bose had appeared. And, my lord, he, my lord, had taken a point that now, my lord, the partnership firm has been dissolved in view of section 42 subsection C of, my lord, the Partnership Act. That, my lord, there were only 2 partners in a partnership firm. One of them has, my lord, expired. So, my lord, the partnership has come to an end. This was a stand, my lord, taken from the bar, my lord, though it is not reflected in their affidavit. If your lordship kindly takes my application, my lord, your lordship will find, my lord, we have given, my lord, the details of, my lord, the heirs. Your lordship will find it in paragraph 5 of my application. Your lordship kindly, my lord, takes, my lord, the names of, my lord, the heirs of, my lord, the defendant number 2, my lord. Prabha Saraf, my lord, page 4, my lord, of the application.
Prabha Saraf.
Prabha Saraf,
Nupur
Kejriwal, Shweta Agarwal, and Shikha Patodia. Now, my lord, with regard to, my lord,
defendant number 2,
Shikha Patodia, my lord, they said, if I am not subject to correction, they said that she lives in the United. Oh, I'm sorry. It's Shweta Agarwal. She said, they said that Shweta Agarwal is in the United Kingdom. They do not know their address. We, my lord, tried to find out, my lord, the address of Shweta Agarwal. It was, my lord, pending because of that reason. We even wrote to the High Commission. My lord, we tried to find out, my lord, the name, and we were in the process of making some kind of publication, and we were approaching your lordship for that publication. Now, my lord, in that, my lord, at that juncture, my lord, they came up with this my lord, submission that now, my lord, the partnership has been dissolved. There is no more partnership, and none of the heirs can be brought in view of Order 30, Rule 4. My lord, before going into, my lord, the judgments, my lord, I want to, my lord, place certain provisions before your lordship. And prior to that, my lord, on facts, if your lordship kindly takes, my lord, what is the case made out in the plaint? If your lordship kindly takes the plaint once, plaint ache ekhane?
Yes.
আমি মার্ক করেছি তার এক Your lordship kindly takes note the plaint paragraph 2. The defendant number 1 is a partnership firm. The defendant numbers 2 and 3 have represented to the plaintiff as being partners of the defendant number 1. Now, if your lordship kindly takes
the partnership firm.
Yes.
Number 2 and 3
have represented to the plaintiff as being partners of the defendant number 1. Now, if your lordship kindly takes paragraphs 4, 5, 6, and 7. Very small paragraphs, my lord. May I, my lord, go through those paragraphs, my lord? The defendants acknowledging receipt of such loan of rupees 50 lakhs and the agreement for interest at the rate of 17% issued a money receipt dated such and such, copy whereof is annexed. The defendants, kindly marks this, my lord. Everywhere your lordship will find, my lord, the name, my lord, the plural form has been mentioned. The defendant.
You are appearing for whom?
I am appearing for, my lord, the plaintiff who has obtained, my lord, an order, my lord, where, my lord, conditional leave to defend was given to them, a summary judgment application. Conditional leave, they, my lord, failed to put in the condition, the money, the security. So, my lord, now it has been, my lord, the defense has been struck off. Now, my lord, they want to contend that they don't want to even bring in the heirs of the defendant number 3, saying that it is a partnership action. You should restrict yourself only to the partners. You cannot go to the heirs of the partners. To that, my lord, if your lordship kindly recollects, Mr. Ghosh had, my lord, submitted, my lord, that if supposedly, my lord, a partnership firm has got 100 crores worth of assets, which, my lord, requires to be distributed, will not the heirs of the defendant number 2 get, my lord, be a beneficiary to, my lord, all the assets of the company? So why isn't the liability of the firm foisted on, my lord, the partners?
So your application for substitution?
My application is for substitution of the heirs of the defendant number 2.
Sorry, yes.
Now, my lord, if your lordship in that respect, my lord, kindly sees this, my lord, paragraphs 4, 5 and 6. Everywhere your lordship will find, my lord, our consistent case is that it is the defendants against whom we have claimed the reliefs. Subsequently, interest was renegotiated at 18%. I'm reading paragraph 5. Subsequently, the interest was renegotiated at 18% with effect from December 1, 2011. And the defendants accordingly paid interest at the rate of 18% per annum thereon. Now, when the said loan was renewed from time to time, it was ultimately agreed that the loan would continue with the defendants until the loan was recalled by the plaintiff, subject to the defendants making payment of the interest which was payable quarterly to the plaintiff. Paragraph 7 also, I'll not read the entirety of the paragraph. Your lordship kindly takes it from me. The defendants paid interest on the said loan of rupees 50 lakhs. And thereafter, next sentence starting with the defendants also deposited tax deducted at source TDS to the credit of the plaintiff. Paragraphs 8 and 9 are also similar, where I have used specifically claimed reliefs and specifically arrayed the defendants as partners as well as individual capacity. If your lordship sees, the defendants has failed to make payment of interest on and from October 1, 2013. The defendants continued, paragraph 8 I'm reading, next page, page 4. The defendants continued to request the plaintiff for extension of time. Thereafter, paragraph 9, the defendants in acknowledgement of their liability also issued confirmation of accounts, etc. Now, most interestingly, if your lordship kindly sees, paragraph 17 and 18, and thereafter I'll go to the prayers, I'm sorry, starting from paragraph 15. Page 6, starting from paragraph 15.
Yes.
Despite demands having been made, the defendants have failed and neglected to refund and or repay the said sum of rupees 50 lakhs along with interest. Thereafter 17, thereafter, we have set out the particulars. There all in the paragraph, setting out the particulars, also, we have claimed against the defendants. 17, it is the defendants, who are liable to pay interest. And paragraph 18, it claims a decree of rupees 1 crore 5 lakhs, that is with interest, against the defendants, and kindly marks the word thereafter, and each one of them. And each one of them. Now, if your lordship kindly takes the prayer, it's on the similar line, page 8 of the plaint. First prayer, decree for a sum of 20.
Yes.
Decree for a sum of rupees 1 crore 5 lakhs against the defendants and each one of them, as pleaded in paragraph 16 above. The lordship kindly also takes even in the averments made, paragraph 20, the previous page kindly takes the previous page, page 7, paragraph 20. I have specifically pleaded that the plaintiffs have come to learn from the defendants and each of them are seeking to transfer their property. So specific allegations against all the defendants. my lord, this is, my lord, the case that I have made out in the plaint. Now, apropos this, your lordship will kindly take, my lord, the provisions of, my lord, the law, which is prevailing. Your lordship has CPC. Your lordship kindly takes, my lord, order 31. It is not as order 30, my lord. It is not a simpliciter suit where a partnership firm has been impleaded without the partners. My lord, if, my lord, I implead a company, my lord, the action is against the company. If I implead the directors of the company, knowing that company is a juristic entity, though I'm not contending that a partnership is, but my lord, knowing the company is a juristic entity, if I implead the company and its directors, so my lord, it is axiomatic that I am actually praying or claiming reliefs against the directors of the company as well. If your lordship, my lord, kindly takes, my lord, so that is why, my lord, I showed your lordship the plaint, that, my lord, it is not a case that it is a simpliciter partnership action that the money is being owed by the partnership and I am claiming reliefs only against the partnership firm. Kindly takes, my lord, order 30, rule 1.
Yes.
Suing of partners in the name of the firm. Any two or more persons claiming or being liable as partners and carrying on business in India may sue or be sued in the name of the firm, if any, of which such persons were partners at the time of accruing the cause of action. And any party to a suit may in such case apply to a court for a statement of the name and addresses of the persons who were at the time of accruing of the cause of action partners in such firm, to be furnished and verified in such manner as the court may direct. Where persons sue or are sued as partners in the name of their firm under Subrule 1, it shall, in the case of any pleadings or other documents required by or under this code to be signed, verified, or certified by the plaintiff or the defendant, suffice if such pleading or other document is signed, verified, or certified by any one of such persons. So, my lord, it is a specific case that, my lord, initially, if a firm is sued and a partners is impleaded, if, my lord, the details of the partners has to be provided, which we have sought for. Whatever details we had of the partners, of the heirs of the deceased partner, we have given, and we have sought for further details that you please tell me if there are any partners being brought in. They say orally, very clearly orally, they say on submission that the partnership has dissolved, though that's not their stand on affidavit. Now kindly seize 2, where a suit is instituted by partners in the name of their firm, the plaintiffs or their pleader on demand in writing by on behalf of any defendant forthwith declare in writing the names and place of residence of all the persons constituting the firm on whose behalf the suit is instituted. Where the plaintiff or their pleader fail to comply with any demand made under Subrule 1, all proceedings in the suit may, upon an application or for that purpose, be stayed upon such terms the court may direct. Where the names of the partners are declared in the manner referred to in Subrule 1, the suit shall proceed in the same manner. I'm not reading the proviso. Now, kindly straight away takes Rule 4, what they are relying on. Right of suit on death of partner. Notwithstanding anything contained in Section 45 of the Indian Contract Act. I'll go through the Indian Contract Act. Section 45 of the Indian Contract Act, where two or more persons may sue or be sued in the name of a firm under the foregoing provision, and any of such person dies, whether before the institution or during the pendency of any suit, it shall not be necessary to join the legal representative of the deceased as a party to the suit. So, my lord, first condition is it is subject to Section 45 of the Indian Contract Act. The second condition is where two or more persons may sue or be sued, very importantly, my lord, kindly marks this, in the name of a firm. In the name of a firm is, my lord, the key phrase, which is, my lord, which gives away the fact that, my lord, if it is not in the name of the firm only, then, my lord, Rule 4 will not be applicable.
Yes, sued in the name of the firm.
Yes, may sue or be sued in the name of a firm.
Correct.
Under the foregoing provisions, and any of such person dies, whether before institution or during the pendency of any suit. So, my lord, I have showed my plaint, the suit that I have filed. It's not only in the name of the firm, I have specifically implemented the partners, and I have also claimed reliefs from each of them.
Yes.
Now, if your lordship kindly takes, my lord, for the sake of my lord, completing my lord, the provision, my lord, Order 30, Rule 4, my lord, Sub-Rule 2 says, my lord, nothing in Sub-Rule 1 shall limit or otherwise affect any right which the legal representative of the deceased may have to apply to be made party to the suit or to enforce any claim against the survivor or survivors. Now, if your lordship kindly takes from Section 45 of the Indian Contract Act.
Yes.
When a person, Section 45, when a person has made a promise to two or more persons jointly, then unless a contrary intention appears from the contract, the right to claim performance rests as between him and them, with them during their joint lives, and after the death of any of them, with the representative of such deceased person jointly with the survivor or survivors. Kindly marks this, my lord. So this is the exception which has been, my lord, inbuilt in the section.
Yes.
And after the death of the last survivor, with the representatives of all jointly. So question of not bringing the heirs of, my lord, the deceased partner is, my lord, subject to Section 45. Section 45 clearly stipulates that the representative of the deceased persons should be brought in jointly with the survivor or survivors. And if the last survivors, after the last survivor's death, it's the representatives who should join, all should join jointly. Now, if your lordship kindly takes the Partnership Act.
Section 43.
But initially, I'll be placing reliance on Section 42, what they have relied on.
Yes.
Though there is no dispute with regard to that fact. Kindly, bears with me.
पार्टनरशिप रेट कितना है? बात किए वाला काय पिछला बार चेंज कर दी. चलो. Yes.
Yes. If your lordship kindly takes Section 37 prior to Section 42.
37.
37.
Yes.
Right of outgoing partner in certain cases to share subsequent profits. Where any member of a firm has died,
yes,
or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement of accounts as between them and the outgoing partner of his estate, then in the absence of a contract to the contrary, the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of the profits made since he ceased to be a partner as may be attributable to the use of his share of the property of the firm or to interest at the rate of such and such on the amount of his share in the property of the firm, provided that where by contract between the partners as an option is given to the surviving or continuing partners to purchase the interest of the deceased or outgoing partner. This is not something else, but initially, Section 37(1) provides that, my lord, if a partner dies, then, my lord, kindly, my lord, do away with the portion that the surviving partners continue with the partnership business. Kindly takes, my lord, in the absence of a contract to the contrary, the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of the profits made since he ceased to be a partner. So before he retires, whatever accumulation of wealth, whatever is there, he will be entitled to it. If not him, if he dies, then his representatives, which means the legal heirs, his other representatives, are entitled to such share of profits, which I am not submitted, or which Mr. Ghosh had submitted, giving a hypothetical situation that if 100 crores
So
worth of profit.
That's why this court has asked. So you have the plaintiff, your simple case is that you have lent an advance amount of 50 lakhs. Fortunate or unfortunate, the person died. Now you file the suit. Fortunate, unfortunate, died. So now you, being a legal heirs, wanted to be added as a party, the legal heirs of that one the partner. Correct. And that's why. So the partnership deed contains the clauses. What would be the effect?
Yes.
And if retired, if died, what would be effect of the partner who died or who left?
Yes.
So that's why this clause is there. But none of the party has disclosed the partnership deed.
But they will not, of course, knowing, my lord, they are contesting this application, they will
None
not.
of the parties have disclosed.
And I don't have it because it's a document which is privy amongst the partners.
What is the stage of the suit?
Stage is, my lord, now, my lord, the written statement has been, my lord, done away with because the defense has been struck off.
They are not disclosed. They are not filed written statement.
They had, but it was struck off because, my lord, we got a, my lord, they could not put in, my lord, the conditional, my lord.
Statement, and that was before the non-commercial division or commercial division?
My lord, commercial division.
Commercial. What are the documents disclosed in the written statement?
এটা তো খারাপ কথা বলেনি, written statement আছে এখানে দেখো তো একটুখানি। My lord, it did not strike me. I'm grateful to your lordship, my lord. Kindly একটু দেখো।
My lord, but there's too many things are striking them now.
Right, it's been struck
My
off.
lord,
We were not looking at it.
Reply.
We were not looking at it, my lord, because, my lord, it was,
my lord, harshness of the law, or my lord, the harshness of the consequences of an event, my lord, cannot change the law.
Correct.
So good, bad, indifferent, my lord, good, bad, indifferent. My lord, there were two partners in a partnership firm. They have lent an advance to a partnership fund. One partner has died. So the legal consequences will follow.
Correct.
So that is why, my lord, we have disclosed.
Mr.
But I'll distinguish the judgments, my lord, cited by, my lord, learned Mr. Bose, my lord.
My lord, all I was respectfully submitting is, my lord, your lordship recollects, my lord, on the last occasion, Mr. Ghosh had made elaborate submissions.
Correct.
Now Mr. Sarkar is making. My lord, kindly give us one opportunity to rebut those submissions, because they have completely, of course, Mr. Ghosh was also fair enough to say that, my lord, he is now coming in order to, my lord, so that his suit survives,
No problem.
his
application survives.
But I'll, my lord,
Yes,
find
I
out
got
if I can.
I got it. You have to continue.
The lordship has already seen, my lord, it's there, my lord.
Continue.
But I'll then, my lord, place reliance on it, my lord, after, my lord, perhaps, my lord, I'm done with, my lord, these submissions. My lord, kindly takes, my lord, section 42, my lord. I'm so grateful to your lordship, my lord. Kindly takes, my lord, section 42, my lord. Dissolution on the happening of certain contingencies. Subject to contract between the partners, a firm is dissolved. A, if constituted for a fixed term by the expiry of that term. If constituted to carry out one or more adventures or undertakings by the completion thereof. C, what they are relying on, by the death of a partner. And by the adjudication of a partner as an insolvent. So, my lord, they are relying on C, saying that, my lord, after, my lord, the death of a partner, the partnership has come to an end. Now, if your lordship kindly takes, my lord, section 45. Notwithstanding the dissolution of a firm, section 45 of, my lord, now, my lord, the Partnership Act. Notwithstanding the dissolution of a firm, the partners continue to be liable as such to third parties for any act done by any of them, which would have been an act of the firm if done before the dissolution until public notice is given of the dissolution, provided that the estate of a partner who dies or who is adjudicated as insolvent, or of a partner who, not having been known to the person dealing with the firm to be a partner, retires from the firm, is not liable under this section for acts done after, kindly marks the word, after the date on which he ceases to be partner. So after the death of the one of the partners, he is not liable. But prior to that, he is liable for the entirety of it. So if he is liable, his estate is liable, his heirs are liable.
Yes.
Very clear, my lord. Very clear.
Next.
Now, if your lordship kindly sees, my lord, the judgments which were, my lord, cited. Yes. My lord, your lordship has already, my lord, taken note of, my lord, all the judgments. I will not trouble your lordship by going through each and every paragraph which has been placed, but my lord, I'll place certain paragraphs, my lord, of the judgments. Just to recapitulate, my lord, because it's been very long
Which
since
one?
we last argued. I'll tell your lordship, my lord, kindly give me one.
2019?
My lord, I'll start off, my lord, with the old, my lord, case of, my lord, the Privy Council case, my lord.
No, Mr. Bose has relied upon two judgments.
Mr. Bose has relied upon two judgments, and we have, my lord, relied upon, my lord, 5 judgments.
Correct.
Yeah.
With regard to, my lord,
Yeah, the Mr. Ghosh has already pointed out all this with regard to the Privy Council, Bombay. That
no,
one
this is our judgment.
Yes, your judgment.
This is our judgment. Mr. Bose had cited, my lord, 2 Supreme Court judgments.
Correct.
And, my lord, our judgments, my lord,
2019 volume 10, and it is
Unreported. It is a subsequently
now
got reported.
reported judgment.
Now report.
Now, if your lordship kindly takes, or kindly gives me 1 minute, my lord, this, my lord, finding out, my lord, a file from, my lord, the liquid text, my lord, becomes, my lord, very cumbersome, my lord. Lordship kindly, my lord, permits me, my lord, to place, my lord, the first judgment, my lord, 1890, my lord, ILR, volume 18, my lord, Calcutta 86, which, my lord, lays down, my lord, the law. My lord, is it, my lord, before your lordship, my lord? This is, my lord, a judgment, my lord, of Ram Narayan Narsingh Das versus Ram
Bose
Chandra.
have already pointed out.
Yes.
I have taken note of all. I already taken note of it.
Oh, Mr. Ghosh,
You are the Mr. Ghosh has given. I am telling Mr. Ghosh has given this Ram Narayan Narsingh. Thereafter Manmohan Pandey. Thereafter Perry Sound Engineer. I have taken all the notes.
But I was only.
And Nupur also given the citation. Who is appearing for the Nupur? The other defendant.
Other defendant, yes.
That I have taken note of it.
No, my lord,
Mr. Ghosh has also relied upon 1927 SEC Bombay. Yes, only you give the reply to this SCC of the Mr. Bose. What is your answer to that?
Now, with regard to, my lord, the judgments, my lord, all the judgments, my lord, but all the judgments, my lord, essentially, my lord, really point out that, my lord, Order 30 Rule 4 specifically relates to suits which are instituted in the name of firm. If the name of the alone, and if the name of the firm is there, or the firm is itself only a party arrayed in the suit, then only Order 30 Rule 4 applies. Otherwise, Order 30 Rule 4, the first exception being Section 45, which I have shown of the Indian Contract Act, which also says a survivor. Mr. Ghosh has argued. Kindly permits Mr. Ghosh to thereafter distinguish these two judgments.
These two judgment of Mr. Bose.
Yes. Now, what was remaining is, my lord, distinguishing really, my lord, the judgment cited by Mr. Bose. Now, my lord, kindly, my lord, takes, my lord, the 2019, my lord, 10 SCC 329.
Correct.
My lord, kindly, my lord, see the facts of this case. My lord, kindly come to 331, the internal page 3.
Yes.
Where Justice Subhash Reddy's judgment starts. This civil appeal is filed by the appellants in Jainara and such, dated 9/4/2009, passed by the High Court of Judicature, Andhra Pradesh, Hyderabad, wherever the High Court has confirmed the order dated 1st February 2006 in EA number 6 of 2005, in EP number 122 of 2003, in OS number such and such. By the aforesaid order, learned Second Senior Civil Judge, City Civil Court, Hyderabad, allowed the application filed by the respondent under Section 47 of the Code of Civil Procedure, that is declaring the decree to be null and void. All the appellants herein are legal heirs of Sri Jainara and Mishra, and all the respondents herein are legal heirs of Srimati such and such Begum. During the lifetime of late Sri Jainara and Mishra and late Srimati Hashmatunissa Begum, they entered into a partnership deed dated 14/4/1982. As stated in the partnership deed, late such and such is the owner of open land and structures situated at such and such. After obtaining exemption from the Government of India, Ministry of Defence, New Delhi, both the partners have entered into partnership for carrying on business in real estate by developing the land. It appears that a major portion of the land is already developed, but dispute is to an extent of such and such square meter, which is claimed by the original plaintiff, forming part of property of Paigad compound. Now, paragraph 4. The plaintiff in original suit number such and such filed by late Sri Jainara and Mishra died on 2001, whereas the predecessor of the respondents, late such and such Begum, died on 1996. During the lifetime, the predecessor of the plaintiff, late Sri Jainara and Mishra, has filed a suit in OS number 580 of 1988 on the file of Second Additional Judge, Civil Court at Hyderabad, with the following reliefs: permanent injunction. Now, paragraph 5. The said suit was decreed in 1993 by the trial court, granting the following reliefs. So, the suit is decreed. Then, my lord, paragraph 6. After the death of the original plaintiff, the legal heirs of the plaintiffs have filed execution. Kindly, my lord, mark this line. Paragraph 6. Have filed execution petition before the trial court by claiming the following reliefs. And, my lords, these reliefs are set out. Now, paragraph 7. In the following execution petition, the respondents have filed an application under Section 47 in EA number 6 of 2005 before the Court 2 of Senior Judge, Civil Division, Hyderabad, claiming the relief to dismiss the execution petition as the decree is void and unexecutable. And thereafter, the well-reasoned order, this Section 47 is allowed. Now, the said order is challenged by this 47 order is paragraph 7 only I am reading. The said order is challenged by the respondents by way of civil revisional petition before the High Court of Judicature, Andhra Pradesh at Hyderabad. The High Court, with the impugned order, confirmed the order passed by the trial court, holding that the decree obtained against the predecessor of the respondents, namely Srimati such and such Begum, is not executable against the legal representatives. We have heard such and such. It is contended by, I am not, my lord, going into the contentions. Now, my lord, kindly, my lord, come to paragraph, my lord, 12. I believe Mr. Bose had placed reliance on this paragraph. On the other hand, it is the contention of Sri B. Adinarayan Rao. This is the contention. Lord Senior Counsel appearing for the respondent that as there were only two partners, and on the death of one of the partners, partnership stands dissolved in view of the provisions of Section 42C of the Partnership Act. It is submitted that when the right litigated upon is readable, only in such event decree can be executed. It is submitted that the respondents were not the partners in the partnership deed, and if any clause in the partnership deed which runs contrary to the statutory provisions are void, such clauses are against public policy.
it is submitted that when partnership itself stands dissolved, one of the death of one of the partners, appellant claiming right under a decree, kindly mark this, under a decree obtained by the original partner cannot be executed against the respondent. So this is a case, well, pausing here for a moment, where the person who has obtained a decree against a partner was trying to execute it against the legal heirs of the partners, not at the stage when the suit is pending. Now, but this is also the observation, this is also the submission. Now, my lord, kindly, my lord, takes, my lord, the finding. What is the finding? Kindly takes paragraph 16 and 17. In fact, my lord, 15, 16 and 17. From a perusal of the, this is the finding of the Honorable Supreme Court. From a perusal of the relief sought for in the execution petition by the legal heirs of the original plaintiff, itself makes it clear that the relief sought in the execution petition are going beyond the scope of the decree. It is fairly well settled that the executing court cannot travel beyond the decree. The only question which failed for consideration before the trial court in EA number such and such was whether the decree obtained by the predecessors of the appellants can be executed against the appellants or not. Section 42 of the Partnership Act 1932 deals with the situation of dissolution of partnership on happening of certain contingencies. As per the said provision, subject to contract between the partners, a firm is dissolved if the contingencies are mentioned. Now 16. In the case on hand, as much as there were only two partners, the partnership itself stands dissolved in view of the death of the partner. But this has happened, kindly mark, after the passing of the decree. After the passing. Paragraph 6. It is true that as per the deed of partnership, the partners have agreed in the event of death of either party, their respective legal representatives shall automatically become partners in the partnership firm, and they shall continue to act as partners in the firm till the venture envisaged under the said partnership is completed. And such legal representatives who become partners shall have the same rights and shall be subject to same liabilities and responsibilities as the deceased partner. 18. At this stage, it is to be noticed that once the partnership comes to an end, by virtue of death of one of the partners, there will not be any partnership existing in which legal representatives of late such and such Begum could be taken in. The judgment and decree obtained by late Shri Jayanarayan Mishra against late such and such Begum in pursuance of the partnership deed dated 1982 cannot bind the legal representatives of late such and such Begum. As such, the decree is not executable against them. But I stop here. What is the Honorable Supreme Court saying? What were the facts before the Honorable Supreme Court? Decree passed. Question is whether decree is executable against the deceased partners' legal representatives who were not parties to the suit.
Yes.
Kindly read on, Malad. The said legal representatives of such and such Begum are not the partners of the original partnership deed dated such and such. When such legal representatives are not parties to the contract, such contract cannot confer right or impose obligations arising under it or on any third party except parties to it. No one but the parties to the contract can be entitled under it or bound by it. Such principle is known as privity of contract. When the partnership stands dissolved by the operation of law under section 42C of the Partnership Act, the question of execution, again mark, the question of execution in pursuant of the decree does not arise. There cannot be any contract unilaterally without the acceptance. This is not very important, but this is what Mr. Bose has relied on. Now, I'm not stopping here for a moment. My first point of distinction is that this is not a case where the suit is pending and the plaintiff has come forward for substitution of one of the legal heirs of one of the partners who is by name a party. Not the case. Second, question was whether once a decree is passed against a partner, that partner dies subsequently, whether the decree is executable against the legal heirs of the partners. Question is completely different.
Yes, next.
So, I am saying this cannot govern the situation here. The next is even more not applicable. Kindly see 2024 8 SCC 700.
This is Nupur's judgment and their judgment.
Both have relied upon this 2024 8 SCC 700.
May I take your lordship's leave, Miller? today Mr. Ghosh will finish, my lord, kindly give me any date convenient to your lordship, my lord, so that I can respond.
I'm done, Mr. Bose. I will take 2 more minutes.
Then, my lord, kindly give me any date convenient to your lordship, my lord, where I can come and respond.
That I'm not. My lord, kindly takes this, the facts of this case, my lord. Kindly
Grateful.
come to paragraph, my lord, 3. The respondent number 1 filed a complaint. My lord, one more distinction. My lord, even though I'm saying this is a fail-safe argument, my lord, without prejudice argument, 2019 10S CCSP Mishra, which I just now tried to distinguish, my lord, even assuming.
Which one you're
No, I'm saying the last one that I just placed before your lordship, 2019 10 SCC, the one that I just now placed and tried to distinguish. My lord, assuming it has any, my lord, bearing on the case, my lord, your lordship will see, my lord, no decisions have been, nothing has been decided, my lord, just, my lord, observations. I know observations of Supreme Court are also binding, but, my lord, no law has been discussed, no decisions have been, my lord, looked into. My lord, now, my lord, kindly takes, my lord, 2024 8 SCC 700, my lord, kindly takes the facts. Here, my lord, paragraph 2.
It is reported.
Yes, my lord, 2024 8 SCC 700.
This has been submitted, my lord, by
What is the name of the party?
Annapurna B. Uppin and others versus Malsi Dappa and another.
Reported.
Reported.
Yes. Now reported.
We have a copy.
We have a copy.
It is mentioned.
No, I'll give you a lordship.
No, it is mentioned non-reported.
Yes, that time I believe.
Yes.
এটাই তো দিয়েছো তো my lord, kindly, my lord, sees, my lord, paragraph 2 3 and 4. I'm sorry.
Yes.
Kindly see the fact. Brief facts, paragraph 2. Brief facts given rise to the present appeal are summarized hereunder. 3. Respondent 1 filed a complaint before DCDRF Dhadwad, Karnataka, alleging that he had invested rupees such and such lakhs in partnership firm such and such, which was repayable after 120 months with interest at such and such, which was sought for premature payment, but it was denied on the ground that the same would be paid upon maturity. Respondent number 1 waited for the maturity and he again claimed, but still the payment was not made. 4. Before DCDRF, respondent number 2 herein was arrayed as OP1 as partner of the firm, and the appellants herein were arrayed as respondent number 2 to 5 being the legal heirs of one Basavaraj Uppin. Appellant, so my lord, already respondent number 2 to 5 were, my lord, made parties as legal heirs of, my lord, Basavaraj Uppin. Appellant number 1 is the widow of said Basavaraj Uppin, whereas appellant number 2 to 4 are his sons. Before DCDRF, separate written versions were filed by OP number 1 and OP number 2 to 5. In his written statement, OP number 1 admitted that he was the partner in the firm along with OP number 2 to 5, being the successor and legal representatives of the deceased managing partner Basavaraj Uppin. And the liability of OP number 1 was only to the extent of 10%. He also admitted that the firm was accepting finance from individuals. But 5, paragraph 5, he further stated that if there was no liability of OP number 1, he had been unnecessarily impleaded in order to get unlawful gains by the complainant. Thus, in effect, he admitted his liability of 1/10 of the share. 6. On the other hand, OP numbers 2 to 5 contended that the complaint was not a consumer and my lord had filed the instant complaint with wrong intention. They also contended the complaint was not maintainable in view of section 63 of the Partnership Act, as there were only 2 partners and upon death of one of the partners, the firm came to be dissolved as it was not in existence. The legal heirs of the deceased partner could not be impleaded as opposite parties for recovery of money from the firm. It was also stated that the complainant was one of the partners of the firm. They also denied deposit of 5 lakhs. Well, this is on the facts. Now, my lord, kindly, my lord, says, this paragraph 8, DCDRA VD order dated 2014 allowed the complaint directing OPs 1 to 5 herein to pay a sum of rupees 5 lakhs within 8% interest from such and such. So, my lord, the complaint was allowed. Paragraph 9, aggrieved, present appellate number 1 to 4 filed an appeal before SCDRC Bangalore registered as appeal number. The said appeal was allowed by order dated such and such and the matter was remanded. The order passed by DCDRF was set aside on the ground of denial of opportunity to the opposite parties. DCDRF by an order dated 2000 again allowed the complaint with the same terms as his previous order. Appellants again preferred an appeal before SDRC Bangalore, which again came to be allowed with order dated such and such, and the matter was again remanded to DCDRF. 11. DCDRF by an order dated such and such again allowed the complainant awarding relief as stated in the opening paragraph. Now, my lord, kindly come to paragraph 12.2. In fact, 12.1. The learned counsel for the appellants made the following submissions. It is a specific case of the appellants that they were never part of the partnership firm either as partners or in any other capacity. By an unregistered deed of partnership dated such and such, the firm was constituted, which included the complainant, respondent number 1, husband and father of the appellants, and 3 others. Later on, by another unregistered deed of partnership, the firm was reconstituted, wherein 3 partners have resigned from the firm, which included respondent number 1, complainant. Surviving partners were the husband of the appellant number 1 and the father of the appellant number 2 to 4. Subsequently, the registered partnership deed came into force on 1996, which included all 5 partners who were part of the first unregistered partnership firm. It included the complainant respondent as partner number 2. Thus, the respondent number 1 complainant was a partner in the firm as per registered deed of 1996. 12.4. All the 3 partnership deeds, the 2 unregistered ones and the 3rd registered one, are filed as annexures such and such. The fact as stated by the appellants with respect to respondent number 1 complainant being a partner to the firm is clearly borne out from the reading of the said documents. According to the appellants, once the complainant himself was a partner as per the registered partnership deed such and such, he could not have maintained the complaint for settling the dispute. Then 12.6 is purely commercial, so consumer forum dispute does not lie. Then, my lord, paragraph 12.7. It was next submitted that the legal heirs of the deceased partner of the registered firm could not be impleaded as opposite parties in a complaint for recovery of any investment or any liability of the firm of which their husband father was a partner. It is submitted that not only DCDRF, SDRC, but also NCDRC committed serious error. Now, my lord, rest is regarding 226. I am not troubling your lordship, my lord. Kindly come to 14. We need not go into other details of the arguments raised by the parties. In our considered opinion, once there was a registered partnership dated such and such, there is no further document placed on record by respondent number 1 complainant regarding dissolution of the said registered deed, which continued till the time when the investment was made by the respondent number complainant on 21/5/2002, and hence respondent number 1 complainant would be deemed to be a partner. It is only upon the death of the managing partner Basavaraj Uppin in March 2003 that the status of the firm would cease to exist or would stand dissolved. Secondly, the investment made by the respondent number 1 complainant was for deriving benefit of getting an interest at the rate of 18%. Therefore, it would be an investment or profit or gain. It was a commercial transaction. Therefore, would be outside the purview of 1986. Commercial dispute cannot be decided by summary proceedings under the Consumer Protection Act. 16. Thirdly, there was no evidence on record to show that a fresh partnership deed was executed reconstituting the firm in which the present appellant had become partners so as to take upon themselves the assets and liabilities of the firm. The law is well settled. The legal heirs of a deceased partner do not become liable for any liability of the firm upon the death of the partner.
This is section 45 of the Partnership Act.
This is not section 45 of the Partnership Act.
Correct.
After the death.
Correct. That's why the law is settled. The legal heirs of the deceased do not become liable for any liability of the firm upon the death of the partner.
Yes, only, my lord, your lordship. That's why, my lord, I began by showing my judgments. All this law that the Supreme Court quotes is, my lord, when the suit is only against the partnership firm. Not because, my lord, that is the law under order. But the moment, my lord, you do not file any suit under Order 30 Rule 1 and make all the partners by name a party.
Yes.
My lord, here in this case, my lord, kindly considers this. Even in this case, what are the facts? That the partner who has died was not made a party. He was not a party from the beginning. What the plaintiffs did was he implemented for the first time the legal heirs of the deceased partner as the original defendants.
Okay.
This is not the case here. Here, the original partner was made a party as a defendant by name.
Yes.
He has died. Now I am simply substituting him in the legal heirs in place and state of the deceased partner. This is not the case here. Here, my lord, they were directly, my lord, sued as legal heirs. That is what the Supreme Court says. You cannot sue them.
Okay.
So, my lord, these two cases, my lord, are not factually, my lord, akin to the situation that we are faced with here. My lord, most important, my lord, the plaintiff is the dominus litis. I am the plaintiff. I have instituted the suit. I have chosen to institute the suit against the my lord, partnership firm by name as well as the partners. And I believe my learned junior has once again showed you in all paragraphs of the plaint, the liability is of the partners as well as the partnership firm. I've pleaded that. So, my lord, today my decree will be also what I pleaded originally was also against the partner personally. So once he dies, normal provisions of the civil procedure code in substituting a defendant has to be complied with. But those are my
That's all.
Yes.
Consistent suffering for the plaintiff, consistent suffering for the defendant, counsel for the plaintiff in reply that concluded his argument. Yes.
Only gives a short date minutes.
Counsel for the defendant raised for time for short reply.
But I believe keeps it in the list, my lord. Your lordship is taking up commercial matters, my lord, regularly, my lord.
Let the matter
Monday,
appear
Tuesday,
tomorrow.
whichever day your lordship will.
Let the matter appear tomorrow.
I'm fairly at the top.
Monday.
Absolutely, my lord.
Brothers kept it on?
Monday. Monday it will be in the list.
Very deeply obliged.
Yes. Next.
But I believe, my lord, mentioning was made on my behalf. I'll be some difficulty.
Which
second
one?
half. That matter your lordship was not kept in the list, my lord. I'm sorry.
Item number
Yes.
on behalf of the judgment debtor, in this matter, we have filed one application for appropriate order, which is to be listed on Monday. And we will also be making some payments. So if the matter is listed on Monday.
Lord, they are saying my execution application is premature because Lordship had permitted.
Because they are not paid the amount. That's the
Your lordship, let the
But
matter
let
be
it
taken
paid
up
the
on
amount
Monday.
that the amount is not paid, the application is premature. It is correct.
Your lordship, we will be paying one installment Monday. Let the matter be listed.
Interest that was their conduct.
My lord, they had said 18% interest was huge, which is why your lordship had considered their submissions and had recorded
But there is-
10%.
but there is-
How much amount you have received?
My lord, nothing.
He's telling that some
No, they say
Your
they
lordship,
want
we
to.
have
my
we
lord.
have prepared a draft of 2 lakh rupees. We will paying them on Monday. Let the matter be listed on Monday.
So suffering for the decree holder, so suffering for the judgment debtor. As per the prayer made by the counsel for the judgment debtor, let the matter appear on Monday. Monday क्या है?
সোমবার
24 তারিখ লেখা আছে
21.
24 your
My lord,
lordship.
that is on Tuesday, my lord.
Tuesday.
Yes.
24 June.
24.
My lord, is it your lordship's pleasure to record that they want to, my lord?
Let them come on then.
Very well. Great.
affidavit of service भी kept करो
Affidavit of service we kept with that.
grateful great
Yes. Item number 17.
My lord, I am appearing for the judgment data number 6 and 7 in this matter. My lord, we have preferred an appeal against this judgment, which is, my lord, which was taken up on 23rd of May, and the appellate court was pleased to fix it next week, my lord, on Friday. My lord, on 27th June, my lord.
The money suit, na?
It's a money
There
suit.
money suit admitted without the deposit
My
of
lord,
the
the appeal,
applicant.
appeal has been admitted again.
How?
The appeal has been preferred. My lord, if I may place the facts in a nutshell, my lord. My lord, it's a suit for recovery of money for goods sold and delivered. There's an due around of in excess of 3 crores. My lord, the appeal has been preferred by the transporter. My lord, the transporter has transported the goods from one point to other point. My lord, they are not involved in the entire transaction. It's for recovery of money for the money not paid against the goods, my lord. My lord, we have preferred the appeal, my lord. The appellate court had fixed it on next Friday, my lord. That I'm humbly seeking for an adjournment for 2 weeks, my lord.
Sense
My lord, I appear for the decree holder in this matter, my lord.
and suffering for the decree holder, and suffering for the judgment debtor. Counsel for the judgment debtor submitted the decree holder and the judgment debtor has preferred an appeal and it's fixed on
27 June.
27 June 2025.
Now, well, in this regard, one fact needs to be indicated to your lordship, my lord. There was a specific direction by the court indicating the division bench, my lord, indicating that there would be no stay. They have not pressed for any stay, and it's a money decree, my lord. So that can very well be put into.
That's why when he stated that, I asked the question whether you paid the amount. So he has stated that no, it has been admitted. So that's why I thought some concession has been granted by the court to him without the over and above the procedure.
My lord, there is no stay.
No stay. In fact, my lord, the Honorable Division Bench has clarified that there would be no stay.
Fix it next week, my lord. Kindly adjourn it for some time.
Might be.
Might be. Counsel for the decree holder submits that though the appeal is filed and admitted, but there is no stay in the suit.
Now, my lord, there's one more thing that my lord, that I need to indicate. The appeal has been preferred by the judgment data number 6 and 7. Now, my lord, I intend to proceed against the rest of the judgment debtors as well. The defendant, the judgment data number 5 is within the jurisdiction.
That is the affidavit of service against the other. He is appearing. We are appearing for
my lord,
6 and 7, my lord.
Decree holder, judgment debtor number 6 and 7. What about the other? Where is that?
Others, my lord, we have served. My learned advocate on record must be there, but nonetheless, my lord, we have served. And in any event, my lord, the decree has been put into execution within 2 years. So I'm under no statutory mandate, my lord, to serve it upon them. So, my lord, I understand your lordship is pleased to fix it on some particular date, but nonetheless, my lord, in respect of the other judgment debtors, my lord, we can proceed against them. So, my lord, let there be an order of
the judgment debtor. Acha, submitted though the appeal has been prepared, but there is no stay. Full stop. The decree holder filed the affidavit of service showing that service has been affected to all the judgment debtors. Full stop. Though the judgment debtor number 6 and 7 have filed the appeal and is listed on 26, but the other have filed any appeal? No. But the other judgment debtors are not appeared in spite of service of notice. In view of the above, the other judgment debtor number 1, 2, 5, and 8 are directed to file their affidavit of assets. In view of the above, all the judgment debtors are directed to file their affidavit of assets within 3 weeks, within 4 weeks. List the matter on 24th of July 2025.
My lord, if I may also pray for my lord, order of injunction restraining them from dealing with the properties, whichever they have. I've indicated that in my tabular statement, my lord, column 10.
Come on that day, we'll see to that.
Very well, very well. Yes, sir.
Number 7.
I appear for the plain pay. AGRA.
AGRA. LALIT AGRA WAL.
Yes, next.
Next. Shown documents, copies whereof appear at page 364 to page 367 of the judge's brief of document. What is this document?
This is the list of finished goods damaged during Amphan.
Finished goods.
damaged during Amphan, along with the supporting documents. This is original printout of the email, original printout of the Excel sheet prepared by me. And we have submitted affidavit under section 65B of 1867. Under section 65B of 1867. Evidence Act.
1872.
1872. Okay. 1872.
What do you have to say about the contents of this document?
They are true and correct.
Do you see any signature at pages 365 to 367 of the judge's brief of document?
Yes. They are signed by Austin Private Limited, by the authorized signatory.
How do you know the signature of the authorized signatory?
This is in the usual course of business because he is directed to sign the signatures.
Allowed different person and a different entity. Austin is for the Glen, is the plaintiff. So, my lord, I object to the identification of the signature. He's not signed it, and the plaintiff is Glen here, and that has been created, manufactured by Austin. It's a different identity. So he's producing that. Page 365, my lord.
Yes.
But I'll exhibit these documents, the other documents, but subsequently, when the Austin's business has been transferred in favor of the plaintiff. There is an agreement also which we have given inspection of, and we'll adduce that in evidence. But he's saying that he knows the signature, and that is why, I would ask. I've still not asked the question. I would ask him to encircle, since he has identified the signature. The objection can go in, but the objection.
With the objection, it will go.
Yes, with the.
Although I've submitted on the last occasion also, but we stand by the admission and denial of the documents, because in each and every document I am not making separate objections, but this is as per what we have stated. That
No. You file the affidavit, but at the time, see, you might have been given the affidavit. That's why on the basis of your affidavit affidavit of document, if the document is placed, if you want to raise, you can raise. It can be mentioned in the exhibit. Otherwise, it will be difficult for you.
My lord.
Can you identify the person who has affixed his signature at pages 365 to 367 of the judge's brief of document?
No, I don't know the person who has signed the document. It is signed by authorized signatory.
Were these documents delivered to the defendant?
Yes, along with the claim file.
And may this be, I'll not ask him to encircle, he doesn't know the name. But may this document be exhibited.
Exhibit
QQ.
Huh? QQ with objection.
Shown documents, copies whereof appear at page 368 to 489 of the judge's brief of document. What are these documents?
The first page is an Excel sheet, original printout of the space required for repairing of injection molding machines of molding machine of JSW Japan, and for Izumi China. Izumi, YIZUMI. The second page is the list of spares. And all the other pages, sorry. Then next 8 pages are the service reports, followed by inspection report of machines by the service engineer of the company. And rest of the pages are the import invoices along with bill of entry, of lading or airway bill, bill of lading or airway bill, commercial invoices, freight invoices, etc.
Who has prepared the documents appearing at pages 368 and 369 of the judge's brief of document?
I have prepared the documents.
This all documents are objected, my lord.
No,
This all relates to that. I will argue on this, or I will cross on this. This is all of the Austin, not of the Glen, that is the plaintiff. My lord, when they merged or something, that is another fact and issues, but I object to this all documents contains and all.
Insofar as, how have you come in possession of the documents appearing at from pages 370 to 489? 486 of the judge's brief of document?
In fact, I was the director of Austin Private Limited also until 2021, October. So therefore, the entire claim file of Austin Private Limited is also prepared by me.
How did you get the documents?
These are documents delivered by Austin Private Limited to us.
How have you obtained the document appearing at page 487 and 487 of the judge's brief of document?
This is a bank statement evidencing the payment to the recipient or supplier of the spares.
Is this the original document?
It's a copy of the original document.
How have you obtained the copy?
This has been given by Austin Private Limited, and it has been submitted in the claim file also.
Lord, this is objected. This document is objected.
What is the document appearing at pages 488 and 489 of the judge's brief of document?
First email pertains to first email is dated 15 June 2020. First email 15 June 2020 at 12:55 hours by Mr. Bharat Bhushan Behera of Prevision World, of Bharat Bhushan Behera, B-E-H-E-R-A, of Prevision World, stating that they will not be able to travel for the inspection or repairing of the machine. Rather, they will support by video calling. And the trail mail dated 15 June 2020 at 11:04 hours is written by Mr. Sardindu Chakrabarti on behalf of Austin Private Limited to Prevision World.
How have you obtained the documents appearing at pages 488 and 489 of the judge's brief of document?
They have been delivered by by Austin Private Limited to us.
My lord, these contents are objective.
Yes, I will let it come. I am not exhibiting.
Yes.
What do you have to
When
say
it
about
will come as exhibit, I will record you.
what do you have to say about the contents of your all your documents?
Yeah, they all are true and correct.
Where is the original document? Where are the original documents?
The email is the original printout, but all the others are photocopies which are delivered by Austin Private Limited to us.
Who made the photocopies?
Photocopies is made by me only.
Have you compared the photocopies with the originals?
Yes.
And may this document be
Exhibit
all these
R,
documents.
RR come with objection.
Collected.
But I'm sorry, Marad, one more question only. Have you submitted any affidavit in support of the electronic records?
Yes, we have submitted.
RR with objection on the ground that the documents belongs to Horton. That is our objection.
Collective.
Collective.
Collectively, Marad. Shown documents, copies whereof appear at pages 490 to 520 of the judge's brief of document. What is the document appearing at page 490 of the judge's brief of document?
This is summary of spares required for the chillers.
Who has prepared this document?
I have prepared the document and its original printout of the Excel sheet.
Have you compared the printout with the original?
Yes. This original document, this original printout of the Excel.
490.
What do you have to say about the contents of this document?
This is true and correct.
What are the documents appearing at page 491 to 520 of the judge's brief of document?
491 to?
Not 520, I'm sorry. To page 514 of the judge's brief of document.
491, 514.
First, it is a 1, 2, 3, 4, 5, 6, 7, 8. First 8 pages are the service reports of Prasad GKW and Nuvu 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 Conair, who are the original supplier of the chillers. And the rest of the pages are performa invoices, payment proof for the spares.
Objected, my lord.
What do you have to say about the contents of the documents appearing at pages 491 to 514 of the judge's brief of document?
They are all true and correct.
How have you obtained these documents?
They have been delivered by Austin Private Limited to us.
Where are the originals of these documents?
Originals are lying with Austin Private Limited.
Were these documents delivered to the defendant?
Yes, along with the claim file.
What do you have to say about the contents of these documents? Sorry. What are the documents appearing at page 515 of the judge's brief of document?
This is a bank statement of Axis Bank evidencing the proof of payment of rupees 1,92,872, which is highlighted.
How have you obtained this document?
This is handed over by Austin Private Limited to us.
Is this the original document?
Original document is with Austin Private Limited.
Who has made the photocopy?
I have made the photocopy.
Have you compared the photocopy with the original?
Yes.
What do you have to say about the contents of this document?
They all are true and correct.
What is the document appearing at page 516 of the judge's brief of document?
This is an invoice from Prasad GWK for the service charges amounting to rupees 49,560, including GST.
How have you obtained this document?
They are handed over by Austin Private Limited to us.
Where is the original document?
Original is with the Austin Private Limited.
Who has made the photocopy?
I have made the photocopies.
Have you compared the photocopy with the original?
Yes.
Was this document delivered to the defendant?
Yes, it is part of the claim file.
What do you have to say about the contents of this document?
This is true and correct.
What are the documents appearing at page 517 to 520 of the judge's brief of document?
517
to 520.
7, 8, 9. 1 8 बोलते 1 7 बोलते 1 7 तो एखान থেকে Page 517 is the payment proof made to Nuvu Conair. $518 is the invoice from Nuvu Conair for the service charge amounting to rupees 16,520. 16,520. And page number 520 is again payment proof paid to Prasad GWK for 48,930. Prasad GWK for rupees 48,930.
How have you obtained these documents?
They have been delivered by Austin Private Limited to us.
Where are these original documents?
No, they are photocopies of the original document.
Who has made the photocopy?
I have made the photocopies.
Have you compared the photocopy with the original?
Yes.
What do you have to say about the contents of these documents?
They all are true and correct.
Have you submitted any affidavit in support of these documents in terms of section 65 capital B of the Evidence Act?
Yes, yes, wherever required.
But I'd like to see 517 because the copy is very illegible. Very difficult, my lord, to even read.
Yes.
In the judge's brief on it is illegal. Little illegible. This is
How
what
it can
he
be
has.
exhibited?
What the plaintiff has, Manoj, and this document has also been submitted to the defendant. As he has deposed, these documents have also been submitted to the defendant.
Maybe, but before the court, you should be give the legible copy.
But this is the printout.
You are the party. You have to prove your document.
Yes.
Then.
But may I put one question to him on this document? 517. Can you explain the contents of the document appearing at page 517 of the judge's brief of
Well,
document?
this will not go. This is leading.
It's the content. I'm
No,
not
no.
asking about the content.
He's not the author.
But he can explain. I'm not saying that he has prepared it. He has obtained.
He has obtained, and it's the eligible copy. How he may say, but at the time of judgment, court has to take the document, not the statement.
That is so. That is so. But insofar as the contents are concerned, if he can decipher something,
Already stated the true and correct. Then
if he could explain, because otherwise, this is the document that the plaintiff
he's
has.
telling that the original is with the Austin. Why you're not bringing the Austin?
But
document.
those documents I'll tender subsequently. But the Austin Private Limited, the company, has been taken over by the plaintiff.
That's
Now,
why
the Austin.
if the plaintiff has taken over the Austin, so where the original must be with you. He's telling that in each and every evidence, it is coming, the original is lying with the Austin, and second hand, he's telling that the Austin, you have taken the Austin.
Yes, there is a business transfer agreement which I'll tender. But may these documents for the time being be kept aside. But we will try if we could bring a typed copy or a legible copy of these documents.
Correct.
Documents were appearing from pages 517 to only 517. Documents appearing at page 517. That is the only document.
What are the page? What are page numbers? और उसमें क्या page numbers है? 490 to 520 are marked as exhibit SS with objection, as the document belongs to Austin, OSTRN, Austin, except the document available at page number 517.
517.
As the same is not illegible.
Shown documents, copies whereof appear at page 521 to 565 of the judge's brief of document.
Mr. Dasgupta, you will adduce the evidence of Austin.
But he's the one who will.
And you are not bringing the original?
But we will try to.
No, that's why saving of the court. If you want to bring the original, why you are wasting the time of the court? Again, you will bring the original. Again, it will be exhibited.
But there is no other witness because he. But I should not say this, but he is aware of all the facts.
Okay. Okay. Continue.
Well, one short thing, but short submissions, because I do not want to put every objections to the Austin Private Limited documents, but let it be categorically objected, because my point is same argument.
Okay.
What are these documents?
These documents are first page is a list of small spares imported from China. Second page is the mold heaters purchased from Arihant. Mold heaters. Arihant. And third page is mold HRTC purchased from Taizo, TAIZHOU, Taizo Overseas Limited. And they are original printout of the Excel sheet prepared by me. Next two pages are mold report from Mold Tip Injection Technology Limited regarding their recommendation after audio/video calling for the repairing of the molds. Next two pages are post-inspection report of molds after repairing by Assistant General Manager Technical of the Austin Private Limited.
My lord, 526, my lord, if your lordship kindly sees to it, this document is prepared by a different person as he is speaking. So how the
That way I am taking objection.
Yes.
No problem.
And the rest of the pages are tax invoices, commercial invoices, bill of entry, forwarders invoice, quotations, payment advice of to the supplier, payment invoices of the purchases, not to supplier, or the purchases.
Who has prepared the documents appearing at page 526 and 527 of the judge's brief of document?
Yes, this is the document, post-inspection report of notes, prepared by one Mr. Sardindu Chakravarti, Assistant General Manager, Technical.
How do you know that this, no, do you see any signature?
Yes.
And stamp on these documents?
Yes, it is signed by Mr. Sardindu Chakravarti and stamped by Boston Private Limited.
Are you aware of the signature of Mr. Sharodindu Chakraborty?
Yes, I am aware because he is now employed by us.
Can you encircle his signature in blue ink on these pages?
Yes.
Encircling is totally objected, my lord.
Duty पे है.
526.
Duty पे है.
In blue.
What is the document appearing at page 537 and 538? কয়েকটা পাতা লিখে 537, 538, 540, 542, 544, 545,
Starting from?
I'll repeat. 555,
537 is
just a second, let me complete the question. 561, 563, 564, and 565 of the judge's brief of document. Page number ওনাকে বলুন।
This is a copy of the SWIFT, SWIFT, SWIFT message for the payment to overseas supplier. But 538 also is a copy of the SWIFT. .540 again is a copy of the SWIFT of the payment proof made to the supplier. .542 is again a copy of the SWIFT of the payment proof to the supplier. .544 is again copy of the payment proof made to the supplier by HDFC Bank. এটা কি ছিল? 545 is tax invoice from Glen Industries Private Limited, on Austin Private Limited for an amount of 15,01,939. .561 is a copy of the bank statement of Axis Bank evidencing payment to Anupam Heaters for an amount of 3,89,628. .563 is copy of the SWIFT of payment made to the supplier by HDFC Bank. .564 is import advance remittance advice of the SWIFT by HDFC Bank. This is the second page of the imported import advance remittance advice.
How have you obtained these documents?
Some documents are belonging to Austin Private Limited. Some documents are belonging to Glen Industries Private Limited. To Austin Private Limited. And some documents are belonging to Glen Industries Private Limited. And I have made copies of the same from the original.
Where are the original documents?
Original documents are lying with Austin Private Limited if they belong to Austin. And of the Glen are with Glen Industries Private Limited. Austin Private Limited. When they belong to Austin.
When they belong
to Austin. And of the Glen, they are lying with Glen Industries Private Limited.
All are objected.
Yes.
But I was asking whether the question has gone in, who has made the photocopy? Who has made the photocopy?
I have made the photocopies of the documents.
Have you compared the photocopies with the original?
Yes.
What do you have to say about the contents of these documents?
They're all true and correct.
How have you obtained the bank statement appearing at page 561, as well as other remittance, other SWIFT documents?
They come in the usual course of business sent by bank to us.
Were these documents delivered to the defendant?
Yes, it is made as a part of the claim file and delivered to the surveyor and defendant.
But may these documents be tendered? Till page 565.
Exhibit T.
With objection on the ground that some of the documents belongs to Austin.
Shown documents appearing at documents, copies whereof appear at pages.
Just
sorry,
one, just
sorry, I'm sorry. Shown documents, copies whereof appear at pages 566 and 567 of the judge's brief of document. What are these documents?
This is a balance sheet and profit loss statement division wise of Austin Private Limited for the year ending 31st March 2019. Sorry, 31st March 2020.
Who has prepared these documents?
This is prepared by Austin Private Limited.
Are these original documents?
They are the photocopies of the original document.
Where are the originals?
Original are with Austin Private Limited.
Who has made the photocopy of
I
these
have made the photocopies.
Have you compared the photocopy with the original?
Yes.
What do you have to say about the contents of these documents?
They are true and correct.
May this be tendered in evidence.
My lord, with objections, my lord.
TT with objection.
Exhibit U.
You. Okay. You with objection as the documents of Austin.
Collective.
Shown documents, copies whereof appear at page 407 to 422 of the judge's brief of document. What are these documents?
This is copy of the invoice drawn by Glen Industries Private Limited on Austin Private Limited for the spares supplied by them, by them after importation from the original equipment manufacturer, from the OEM manufacturer, along with necessary invoice of the original equipment supplier, way bill, tape copy, bill of entry, and the freight bill. Freight bill. FREIGST, freight bill.
Are these original documents?
No, they are copies of the original document.
Who has made the photocopy?
I have made the photocopies.
Have you compared the photocopy with the original?
Yes.
Where are the original documents?
Original are lying with Glen Industries Private Limited.
Were these documents delivered to the defendant?
Yes.
My lord, objected, my lord.
What do you have to say about the contents of these documents?
They are true and correct.
But here, one of the objection, if I may address it. Yes, said the documents are originals are lying with Glenn, which is the plaintiff.
So
Originals were given inspection.
My lord, there is no notice.
But see, inspection is different thing. Exhibiting the original document is different thing.
This is,
Why
yes, sir, it's a
you are
copy.
not bringing the original? Why you are not bringing the original? I don't think what you will find in the final. All the you are placing all the Xerox document. I don't know how you will prove.
Secondary evidence.
But once he is telling that original is available, now the secondary evidence will come into effect. The witness is telling the original is available.
So will your lordship give me one moment? Will your lordship give me one moment? I'll. May I put one question to him? If required, if required, would you be in a position to produce the original documents? Copies whereof appear at pages 407 to 422 of the judge's brief of document?
Yes, all the documents, original documents of Glen Industries Private Limited can be produced.
Would you be able to produce them on the next occasion?
We'll have to locate the documents because they all have gone into. Okay. You have to give some time for locating the originals from the files.
Let him produce the original. If he can, then I'll tender these documents.
You will have to give some time. I mean, okay, my lord.
But insofar as some other documents are concerned, appearing chronologically, but the same issue is here. But if we may see whether the originals are available with him, then we could produce the original documents and then try and tender those documents in evidence. But for the time being, if your lordship gives
when the next is fixed,
there's no other date fixed.
Date is fixed.
But it may take half an hour to 45 minutes at the most. We don't have much documents to adduce.
Continue. We will continue today.
But issue is this: the originals are not here. So we'll try and see whether the originals are there. On the next occasion, we'll.
Why you not produced the original since beginning? You wasted 3 days time of the court.
Some documents he doesn't have to reveal. It's with some other.
But that has to come from the witness. With the witness is telling. See, two things. You have taken over the Austin. Correct. And the document belongs to Austin. Your witness is telling that the document is with the Austin. Second thing, your witness is telling this document of the Galen. He is the witness of the guardian. That also not produced. Yes, record. Census suffering for the plaintiff. Please step down.
Okay.
Census suffering for the plaintiff. Census suffering for the defendant. Plaintiff witness is present. Examination chief resumed. During his examination, documents were exhibited in exhibit QQ to UU. Police counsel for the plaintiff submitted there are some more documents which is to be exhibited and he prays for time. Accordingly, examination chief of the plaintiff witness is therefore let the matter appear on 4th of August or 4th, 5th, 6th August.
4th, 5th.
You will start cross-examination?
My lord, I will try to take the instruction immediately, but give me at least 3 or 4 days gap after finishing.
4th August. One day you will complete?
One day I'll complete.
4th August 2025 for 4th August, huh? 2025 for further examination chief. And next date though, at kitna baje? At 2 p.m. 3 p.m. 11:30.
But if I could
And
have 1 hour, well, then
11:30 or 12:30?
11:30 to 12:30.
And आगे जो दूसरा क्या एक हफ्ता के बाद देखो।
हाँ।
11th अगस्त काट क्या टाइम है? 11th August 2025 11 and 12th August 2022 at 11:30 for cross exam.
Yes. Grateful Lordship.
Or at 3:30, if my lord permits.
Come at 3:30.
I'll wait.
May I have my lord's kind leave to mention item 38, 39. Of your lordship today's list.
38, 39.
39. There's a hardened part. Those matters, my lord, which relates to a property, my lord, left by mother, 3 sisters. Lordship has heard the matter and
has come.
Since my lord is gone down the list, only for the even Lordship prima facie has already held that there were my lord mismanagement the property. I being the youngest sister, my lord, I suffer.
I remember all this.
Only I say, my lord, if on any day, if the matter may be, my lord, some precedence, I do not say it otherwise, my lord, but since, my lord, its property is being deteriorated and in the hands of all my
Who is for the other side?
Mr. Anirban Bose, my lord, used to appear. And the state, bank, electricity authority, everybody were directed to file report with regard to, my lord.
11:30 खाली है. Other side नहीं रहेगा तो मुश्किल होगा. कोई दूसरा दे.
If your lordship says so, my lord, we can communicate and come back at 3:15 or some.
Okay, let you bring your other side. Then I will fix the date.
Very well, my lord. At 3:15. Very well, lordship. I'm grateful.
My lord, before that,
My lord, item number 2.
of the to be mentioned, my lord, it is for the fixing of a date,
Fixing
my
of the
lord.
date.
Okay. Call the to be mentioned.
One is for only for
Call the to be mentioned.
notes of argument. IAP for the defendants is for filing of notes of argument.
I'm appearing for the plaintiff, my lord.
You have filed the affidavit?
Yes, my lord, on last occasion.
The notes of argument, lordship, we are filing ours.
Record and order. Since suffering for the plaintiff, since suffering for the defendant. Defendant has filed the written notes of argument. Let the same be kept in the record.
Letter করে দিয়ে দেব. My lord, one indulgence, my lord. May I have an order for exchange of the notes of argument?
Copy.
Well, they have not given either.
I shall, my lord.
The parties are directed to exchange their written notes of argument.
Much obliged.
Yes.
And for the defendant, my lord,
The witness action was going on.
My lord, defendant's witness was, my lord.
My lord, last it was fixed on 11th April. My lord, that day the bench wasn't available. My lord, any day, my lord, will kindly fix. Mr. Chaudhary, Shobhushaji Chaudhary.
Suffering for the plaintiff, suffering for the defendant. It is submitted that the case is at the stage of witness action.
Any day, my lord, after 8th July, my lord.
Sync for a specific date and time so that the witness can be examined. In view of the submission made by the counsel for the parties, let the matter give the date for witness action.
My lord, any day after 8th July, my lord.
5th of August at 5th August at 12:30.
Oh, bless.
For witness action, huh? Yes, next. कोई नहीं है, छोड़ दो.
Item 3, my lord, I am there, my lord.
No. Lord, I am for the respondent. Lord, you will remember this matter. The appeal court had said that the interim order would be only till this matter is heard out by my lord. My lord, this went before Justice Mukherjee, but I believe, my lord, submissions were made that this has been extensively heard by my lord. And that is why it has come back. So kindly, my lord, fixes a date, my lord, where I can come back and ultimately Mr. Bose finishes his submissions, my lord.
I was under the impression the way he started that he will disagree and disapprove the submissions that I made before Justice Mukherjee, that it was substantially heard. But luckily he did not.
I am agreeable before any court. I do not have a choice of court as a lawyer.
Neither do have. None of us have.
So that is why, my lord. So I'll be happy anywhere.
Suffering for the plaintiff, suffering for the defendant. It is submitted by the learned counsel for the parties. The matter has been parted and praying for fixing a date and time. In view of the above, let the matter appear. Give the date.
Well, kindly gives like 2 dates, my lord, because seeing Mr. Bose, I can understand.
Mr. Bose,
Fix then.
Well, Lord, kindly give 3. For Mr. Banerjee's convenience, give 3, my lord.
3, my lord, for him to reply back.
6th and 7th August at 12:30.
12:30. Great.
Deeply obliged.
Grateful, deeply obliged.
Yes, next.
This has appeared at my instance, my lord, for an order that, my lord, I shall give an affidavit that I shall not revoke the fixed deposit receipts, my lord, that I am submitting before the registrar, my lord.
Yes. Yes, what is your submission?
My lord, this, my lord, the
Bank,
department.
which bank fixed deposit?
Indian Bank.
Indian Bank.
So the department says, my lord, that the Indian Bank should write that it's lien marked. I'm saying I'll put this on record, and I should also give an affidavit saying that I will not invoke this fixed deposit.
Opening for the petitioner. Counsel for the petitioner submitted in terms of the probate granted by this court. The petition.
Letters of administration.
And letters of administration granted by this court, comma, in compliance of all formalities, comma, the petitioner has submitted the fixed deposit of rupees 1,40,300, 1,25,000 of HDFC Bank and rupees 6,49,000. No.
But in aggregate is 23 lakh. Will it kindly seize the order of 16 January?
Going by the fixed deposit.
Yes,
So
there are two sureties, Millard. So there are two, Millard kindly takes this, Millard. There are two sureties. So both aggregate, Millard, to 23 lakh rupees.
क्या बोला? In terms of the letters of admission granted by this court and in compliance of the order, comma, petitioner has furnished two sureties for an amount of rupees
23 lakhs, Millard. The order of 16 January, Millard, is very clear.
23 lakhs with two sureties, but the office is directed the petitioner to get the fixed deposit of the Indian Bank and to get the mark of lien.
Get a communication from Indian Bank.
Get a communication from the Indian Bank as the said fixed deposit is kept in lien. Fully. So counsel for the petition submit that it is very difficult for the petition to get the said certificate or communication from the bank. Accordingly, counsel for the petition submit that the surety will
will give additional affidavits.
The surety will furnish an undertaking that he will not
invoke the fixed deposit.
The fixed deposit of the Indian Bank
before the maturity date
of the Indian Bank, being fixed deposit receipt number 0932208 dated
But I shall give the numbers, my lord. I shall give the numbers. Kindly leave that blank, my lord.
dated so till the period of maturity.
Because there are two receipts.
Full stop. The petition is director, the surety is directed to furnish the undertaking in the department, and if the surety files the undertaking, the same may be accepted by the department, and the same also become the department is directed to communicate the same undertaking to the bank for information.
Very well. I'm deeply on this. मैं लिखे दे दीजिए नंबरটা लिखे दीजिए ওটা দিয়ে দিন
Yes.
For witness action, my
item number
is there.
Yes.
My witness
present.
is here, madam. The probate of a will, my
Huh?
witness is the first attesting witness.
हिंदी में बोले
First witness.
First witness.
मैं इस मुकदमे में जो कुछ बोलूंगा सच बोलूंगा सच के सिवाय झूठ नहीं बोलूंगा और कुछ नहीं छिपाऊंगा ईश्वर मेरी सहायता करे।
आपका नाम बताइए।
शशि कुमार मिश्रा
SHASHI
शशि कुमार मिश्रा जी
शशि कुमार मिश्रा। पिताजी का नाम
भवानी शंकर मिश्रा BHAWANI हाँ शंकर मिश्रा हाँ भवानी शंकर
मिश्रा। आपका उम्र कितना है?
59।
आप क्या करते हैं?
मैं अकाउंटेंट हूँ।
अकाउंटेंट। आपका रेसिडेंशियल एड्रेस
106 केसी सिंघा रोड केसी सिंघा रोड शिवपुर हावड़ा 2। हाँ जी।
What is your connection with the Pasari family?
लास्ट 30 साल से मैं वहाँ काम कर रहा हूँ।
I have
Pasari family
बोलिए।
30 साल से काम कर रहा हूँ वहाँ पे एज ए अकाउंटेंट। उनका पर्सनल अकाउंट और कुछ कंपनियों के अकाउंट भी मैं देखता हूँ।
I have been working in the Pasari family for the last 30 years and I have been looking after their some personal account
or companies account
and companies accounts.
Some na, their personal,
Their-
some to na.
Their personal accounts and companies accounts.
Why have you come to attend the court proceedings today?
आप यहाँ आज क्यों आए हैं इस प्रोसीडिंग में?
माँ की विल में मैंने विटनेस किया है, इसलिए मैं आया हूँ यहाँ पे।
In my mother's will, I have signed as a witness. Therefore,
In
I
my
have,
mother's will.
But
In
that
the
is
mother's
exactly
will.
how it has gone in Malaj.
In the mother's will,
I can clarify it.
then
but
you
next,
can
no
reply.
problem.
In the mother's will, I am one of the witness. That's why I came to court.
My mother Susila Devi Pasari.
Just.
Uh, when you refer to mother korben na ma korun, ঠিক আছে? When you refer to ma, who do you mean as ma?
आप माँ शब्द से किसको समझाते?
सुशीला देवी पसारी।
सुशीला देवी पसारी।
Why do you refer to Sushila Devi Pasari as ma, quote unquote ma?
आप सुशीला देवी पसारी को माँ बोल के क्यों संबोधन कर रहे हैं?
हम लोग का 30 साल से रिलेशन है। जब भी हम उनके घर जाते हैं और कोई फेस्टिवल होता है तो माँ बुलाती है, हम लोग को रिस्पेक्ट देती है, इसलिए हम उनको माँ के हिसाब से ट्रीट करते हैं।
We have relation with her since last 30 years and she invited us in their house in festivals and several occasions. Therefore, we call them as Ma.
You behave very nicely with us.
And she, in these times, behaved with us very nicely.
Hey, Manutosh.
Who has asked you
चिराग वाला कौन सा फाइल?
to come and
चिराग वही कहीं नहीं जो रोज लेटर लिखता, कौन सा लेटर है? Yes.
who has asked you to come and depose before this court today?
आपको किसने यहाँ आके साक्षी के हिसाब से वो विटनेस करने के बोला?
चंद्रकांत पसारी है।
तो चंद्रकांत पसारी।
Will ta dekha bin. একবার আমার
No, वहाँ थे वो। ठीक है, छोड़ दो, रहने दो।
এটাই original will টা। Witness is shown annexure A to the probate petition. What is this document?
ये क्या document?
माँ की विल है ये।
This is the will of bracket है, माँ है, single inverted comma, माँ, MAAA.
What is the date on which this will was executed?
5th day of January 2021.
प्रोबेट में दिया है ना?
Day of January 2024.
21.
Please come to the last page of this document. Who has signed? Whose signature appears on this page? Can you identify the signatures appearing on this page?
आप ये सिग्नेचर पहचानते हैं?
हाँ, एक है बजरंग लाल डागा, एक माई सेल्फ और एक है सुशीला देवी पसारी का।
बोलिए।
बजरंग लाल डागा,
TAGA.
शशि कुमार मिश्रा।
The second one is of Shashi Kumar Mishra.
और सुशीला देवी पसारी।
And the third signature is of Sushila Devi Pasari.
Shashi Kumar Mishra.
Myself, within bracket myself.
Mine.
That is
DAG.
Who is Bajrang Lal Daga?
बजरंग लाल दागा कौन है?
बजरंग लाल डागा मैं 30 साल से काम कर रहा हूँ, उनके पर्सनल फाइल्स और कंपनी का काम देखता हूँ, ये मेरे कलीग्स हैं।
I have been working since last 30 years, and Bajranlal Daga is my colleague, and I have been looking after his personal files since last 30 years.
His file.
It's not his file.
अच्छा
नहीं कंपनी का कंपनी
No, no.
No, no,
कंपनीज फाइल
Company's files.
पर्सनल फाइल ऑफ पसारी ग्रुप
আনসারটা কি গেল?
কি বল?
So I take it that in course of your employment in the last 30 years, sorry, that would be a, since you have identified Bajranglal Daga's signature, that can be encircled in red.
ये बजरंगलाल दागा का ये सिग्नेचर लाल से witness identity.
You have said that you are the attesting witness to the will of Sushila Devi Pasari. Who asked you to be the attesting witness?
आपको यहाँ विटनेस के तौर पर किसने साइन करने के लिए बोला?
3 जनवरी को चंद्रकांत पसारी जी का फोन आया था मेरे पास। उन्होंने कहा था कि माँ बात करेगी तुमसे, तो माँ ने मुझे फोन कर
On 3rd January, a phone call from Chandrakant Pasari had come, and he told me that Ma would like to speak with me. बोलिए।
हाँ, माँ ने कहा,
Ma said,
मैंने विल बनाया है।
I have
She has
prepared.
prepared a will.
She has prepared a will.
तुम लोग परसों आकर के
You come day after tomorrow
आके इस पे विटनेस करना है तुम लोग को,
and
तुमको और बजरंगलाल डागा को।
and sign as witnesses in this will, you and
बजरंगलाल डागा, मैं उनको भी फोन कर देती हूँ।
and I will call them also.
Third person হয়ে যাচ্ছে আনসারটা।
क्या लिखा है? हाँ। And he told me that mother wants to talk with you.
My mother na.
And
Ma
Ma want to talk with you, and accordingly Ma talked with me and told me that you along with Bajrang Dhaga has to come to my house day after tomorrow as a witness in the will. To sign as a witness in the will.
You said 3rd January. Which year?
21.
2021.
पूरा बोल।
So what did you do after Ma asked you, sorry, when Sushila Devi Pasari asked you to be the witness to her will?
जब उन्होंने आपसे कहा कि इस विल में विटनेस होना है, तो आपने क्या किया उसके बाद?
हम और बजरंगलाल डागा दोनों जो है 5 तारीख को सुबह में 11:30 बजे करीब उनके घर पहुंचे।
अच्छा।
फर्स्ट फ्लोर के अंदर।
धीरे-धीरे।
I and Bajrang Daga on 5th January morning at around 11:30 reached the house of Sushila Devi Pasari. उसके बाद
फर्स्ट फ्लोर में
फर्स्ट फ्लोर इन द फर्स्ट फ्लोर ऑफ द हाउस।
फर्स्ट फ्लोर
ईयर बताइए।
2021
इन द फर्स्ट फ्लोर बोलिए।
माँ ज्योति सेक्सरिया, माँ ज्योति सेक्सरिया और श्री चंद्रकांत पसारी तीनों सोफे पे बैठे हुए थे।
माँ ज्योति सेक्सरिया एंड चंद्रकांत पसारी वर सिटिंग ऑन द सोफा।
हम लोग पहुंचे वहां पे, कोविड का समय था, मास्क लगाया हुआ था हम लोग का।
We reached there and it was the time of COVID and we had put on our masks.
हम लोग वहाँ बगल में डाइनिंग टेबल पे कुर्सी पे बैठ गए जाके।
And we sat on the chair of the dining table beside them.
By the side of the dining chair. By the side of the dining table.
माँ ने पूछा,
Ma asked
कैसे हो?
about Ma asked the how are you? Yes, बोलो तो single in
और सामने में बिल रखा हुआ था।
and the will was kept in front
दाएं
of
सामने
us
सोफे में सामने टेबल पे रखा हुआ था।
on the table, kept in front of us on the table.
माँ ने कहा,
Ma said,
मैंने विल बनाया है,
I have prepared a will.
तुम लोग एक बार देख लो।
You go through it once.
माँ ने विल, हम लोगों ने टेबल से विल उठा करके देखा। मैंने देखा पहले, इसके बाद बजरंगलाल डागा ने देखा।
I went through the will first, and thereafter, Mr. Bajrang Lal Daga went through the will.
वापस टेबल पे रख दिया।
And we kept the will on the table.
माँ ने कहा, मैं साइन कर देती हूँ।
Ma said she would sign first.
इसके बाद तुम लोग साइन करो।
Thereafter, you would sign.
फिर बजरंगलाल डागा ने साइन किया।
Thereafter, Bajrang Lal Daga put his signature on the
विल, हाँ विटनेस में, और इसके बाद मैंने किया।
Thereafter, I signed.
वापस माँ को दे दिया।
And then we gave back the will to Ma.
So when did Sushila Devi Pasari sign the will?
उन्होंने कब साइन किया?
पहले साइन किया, उसके बाद हम लोगों ने साइन किया।
At first, Sushila Devi Pasari signed. Then we put our signature on the will.
How do you know that Sushila Devi Pasari signed before you?
क्योंकि जब हमको विल मिला उस समय साइन किया हुआ नहीं था उसमें।
Because when we received the will, there was no signature on it.
Where were you when she signed the will?
आप कहाँ थे जब वो साइन कर रही थी will?
हम लोग दूर बैठे हुए थे, दूर से देख रहे थे।
We were sitting and looking at her
When she was signed.
When she signed the will.
when she signed the will.
According to you, what was Sushila Devi Pasari's physical and mental state on 5th January 2021 when she signed the will?
5 जनवरी 2021 को उनका तबीयत कैसा था? फिजिकल और मेंटल, मानसिक और शारीरिक दोनों।
माँ देखने में भी ठीक लग रही थी।
माँ लुक फाइन।
और साइन करने के बाद उन्होंने मुझसे पूछा।
And after signing, she asked
कि घर में सब लोग कैसे हैं?
She asked me about the well-being of my family members.
और अब साइन हो गया, तुम लोग नाश्ता पानी करके जाना।
And she said that we should have our tea and coffee after signing the will.
देखने में एकदम वेल अच्छी लग रही थी।
She looked fine at that time.
So did you have tea and snacks as offered by Mrs. Pasari?
आपने चाय वाय पिया था?
नहीं, कोविड का समय था, हम लोग ज्यादा समय नहीं लिया, माँ को दूर से प्रणाम किया और फिर हम लोग निकल गए।
As it was during the time of COVID pandemic, therefore we did not take any snacks. We just made our pranam from far and went.
You have referred to one Jyoti Saksaria. Who is she?
Jyoti Saksaria कौन है?
चंद्रकांत पसारी जी की सिस्टर।
She is the sister of Chandrakant Pasari.
My lord, the chief is over. The chief is over, my lord.
What?
He can start.
I'll just put in 2 or 3 questions, my lord. Thereafter, I continue the next.
This will be ready as.
Yeah, should we go one?
You will addition any other witness?
My lord, the executor has to come, my lord.
Mr. Mishra, how old are you?
59.
What have you been doing before joining the services of the Pasaris?
दूसरी जगह सर्विस करते थे हम.
I used to work in another place.
How long did you work there?
3 या 4 साल काम किए हैं चार्टर्ड का.
3 to 4 years.
Were you an accountant over there also?
Yes.
Hello, I'll continue the next.
Lord, may I request for a short date? I'm requesting. I know your lordship is very busy, my lord. My lord.
Now my diary will not permit.
In fact, my lord, I was a little scared. In the morning, I was waiting for the matter. Suddenly, the list collapsed because the matter had to appear online. I tender my apologies, my lord, for that.
So and so suffering for the plaintiff, so and so suffering for the defendant. Plaintiff witness is present. Examination chief is concluded. Cross-examination is started, but counsel for the defendant press for adjournment. According cross-examination is therefore. Let the matter appear on 8. What time? 8th August, 12:30.
Great.
That is the shortest date.
Try and finish.
We'll definitely try. We'll
Come ready on that day.
But my lord, need to ask too many questions. He's the attesting witness at the end of it. Grateful.
Yes, next.
Your lordship, on the last occasion.
May I any 8th August?
Matter of court number 23?
8th August में नहीं. तो कैसे चल? ना college. Well, may I any other day? 8th August, I will not be there. I have a personal. My college 20 years reunion, my lord. So going for that one.
11th August, 12:30. 11th August, 12:30.
Great.
But on the last occasion, lordship had directed the department to give a report. And I believe the report is before your lordship. No caveat file. What we have been.
Attached to the testamentary device as per the ledger maintained by testamentary device. No caveat has been filed. Yes, then.
Lordship kindly grants and kindly your lordship can and expedite. No, kindly do not. Your lordship kindly grants it and then expedites the process from the department.
Go to the revenue. It is not good.
The beneficiary is 82 years old.
Huh?
The beneficiary and bedridden. If your lordship kindly grants it, he'll be able to see.
That's correct, but it is not good for this court to pass an order, final order.
No, your lordship had directed. Your lordship passed an order for publication. We did the publication. Thereafter, your lordship directed the department. Your lordship kindly.
Where is your PLA?
My application is
PLA का है? Publication. Oh, affidavit service. Where is the will? Who is the petitioner? Kamal Kumar Gopal Das.
Yes,
he is the executor or beneficiary?
Yes.
He is the executor?
Yes, Lord. If your
Where is
lordship
the-
kindly takes.
Yes, I appoint Gopal Das, executor of mine. Yes, then who is the testator? Arun Kumar Hirji. Yes. What is the date of the will?
Date of the will.
26th August 2015. When the die?
9th of August 2015.
When the testator died?
The
23.
death certificate is at
Where is the date on legal heirs?
28th June 2023.
Legal heirs? Only three legal heirs: wife, daughter, and son.
Yes.
And who is he? Who is the petitioner?
Petitioner is the executor, Kamal Kumar Gopal.
Yes, he's not related. No legal heir. He is not the legal heir.
No, madam, no.
So other have filed the affidavit.
Yes, madam, they are filed. Yes.
Where is that?
Consent affidavits are there with all the legal heirs.
Along with the application.
Along with the application, yes.
Where is the affidavit of Devyani?
Wife is Devyani is wife of
Yes, where is the affidavit? मन तो देखो affidavit है Devyani Hirji.
Yes, Devyani Hirji. This is dated 6th of October 23.
नहीं वकालतनामा है affidavit of assets. और दूसरा देखो संध्या अतुल और तीसरा संजय and attesting witness. Who is the attesting witness? Whose affidavit have you filed?
Attesting witness is Hemant Kumar Ved and Sudhir Kumar Mukherjee.
Both have filed?
No, one of them have filed. Hemant Kumar Ved has filed.
So why publication was made?
Well, paper publication was
why paper publication?
But one of the properties were outside. One, huh?
So suffering for the petitioner. The petitioner has filed the present application for grant of probate though. Grant of probate.
Yes.
Of the last will and testament dated 29th of August 2015 of the testator Arun Kumar Hirji, who died on 28th of June 2023, leaving behind three legal heirs, namely Srimati Devyani Hirji, यहाँ से देख लेना, Devyani Hirji, Sandhya Atul Asher, Devyani क्या बोला? Leaving behind her legal heirs, namely Devyani Hirji, wife, Srimati Sandhya Atul Asher, daughter, and Sanjay Hirji, being the son of the testator. All the three legal heirs have filed their respective affidavit of consent, stating that they have no objection for grant of probate of the last will and testament of the deceased to the petitioner. Full stop. The testator, the will was executed in presence of two attesting witnesses, namely Hemant Kumar Ved and Sudhir K. Mulji. Out of the two attesting witnesses, one attesting witness, namely Hemant Kumar Ved, has filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will and testament. For the counsel for the petitioner submitted that as none has come forward for file any caveat or raise any objection for grant of probate, all the legal heirs have filed their affidavit of consent, and one of the attesting witness in his affidavit has categorically stated that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind, and as such the will is proved and the petition is entitled to get probate. Had the learned counsel for the petitioner perused the original will dated 25th August 29th of August 2015, death certificate of the testator who died on 28th of June 2023, affidavit of consent of all the legal heirs, and affidavit of attesting witness. This court finds that the petitioner has proved the will and is entitled to get the probate of the last will and testament dated 29th of August 2015. The department is directed to issue probate to the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number 416 of 2023 is disposed of.
I'm so grateful to your Lordship. If your Lordship kindly directs the department to expedite, because only difficulty is the beneficiary is an 84-year-old.
The counsel for the petitioner informed this court that the beneficiary of the will is 85 years.
Right, 85 years.
85 years and prays for direction upon the department to expedite the matter for issuance of the probate. In view of the above, the department is directed to issue the probate as early as possible on compliance of all formalities by the petitioner. फिर contempt आ गया. The contempt से बड़ा मुश्किल.
Lordship, item 7, I'm for the petitioner.
Yes.
Item 7, I'm for the petitioner. I'm being led by Mr. Rupa Ghosh.
Yes.
Lordship kindly takes it up anytime next week. He's not in court.
What about the contemners?
But contemners were there.
Ah.
Were present.
Ah.
But since my learned friend indicated that they are going to seek an adjournment, we had advised the contemner because one of the contemners.
That matter.
Yes, but we had concluded our submissions.
That.
Lordship, my interim order is expiring today, Lordship.
As per the prayer made by the counsel for so-and-so suffering for the plaintiff, so-and-so suffering for the alleged contemner. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on.
Would it be on 4th?
Huh?
4th of July.
4th of July?
Yes.
4th of July 2025. Interim order is extended till 18th of July 2025 or until further order, whichever is it.
Grateful.
Lordship, I am for the petitioner. In this matter, the appeal filed by the respondent hearing has started. And the next date is fixed on 24th. The appeal court has requested not to proceed for the time being. So I'm praying our next date may be fixed thereafter. 24th, the next date of appeal, hearing of the appeal is fixed, Your Lordship.
So you are appearing for whom?
Petitioners.
So appearing for the petitioner?
No.
So appearing for the alleged contemner? Counsel for the petitioner submitted, the alleged contemner have preferred an appeal. And is fixed on 27th.
24th.
24th of June 2025. In view of the above, the case is adjourned. Let the matter appear on 18th of July 2025.
18th of July.
Lordship, on behalf of the item number 8, on behalf of the trust, small request to your Lordship that as the learned friend said that there is an appeal, so it's my humble request that kindly adjourn this contempt matter till the final disposal.
That's why I fix on 18. If it is open, then we'll see to that.
My lord, item number 9 is I'm led by Mr. Vikas Ranjan Bhattacharya. He is online, my lord. With regard to the formation of association of that matter, 50 Chodungi Road, my lord. Last time your lordship was was passing the order, the other side came.
Let us form the association under the supervision of the special officer. Otherwise, it will never be done.
My lord, I am led by Mr. Bose. I think he's virtually there. My lord, if your lordship remembers, in this matter, there were two applications. One was a modification application of your lordship's main order, which was contempt proceedings and other things were going on. My lord, today, in the modification, they seek for formation of association under the aegis of the special officer. My lord, there is a GA7 which is also pending in the suit, which is filed by them, which is pending before Justice Shogato.
You see, if the association is formed, everything would go.
My lord,
only thing remains to be done is association formation.
My lord, that application is for removal of the same special officer. But that application and this modification under the same special officer formation of an association cannot parallelly proceed. That application has to be either withdrawn.
Pending before this court now.
Milord, GA8. That's the modification.
8.
Yes,
Modification of
yes,
the
yes,
order.
yes, Milord.
But
And
in fact,
GA7.
in fact, well, if the order which we are seeking is passed, everything would be settled.
Yes.
Let the association formation be made complete by the parties under the aegis of special officer. What's the wrong in it?
Milord, they'll have to withdraw GA7 perhaps.
That is a mere
cannot
technical formality.
Milord, so
If
that
the
undertaking has to be given in any order passed in GA8.
If this order is passed, that order
It will be disposed of. I will record the
Yes,
undertaking
yes,
on Mr.
yes,
Yes, no problem.
Yes, Milord. That
No
is
problem.
Mr. Bose is there.
Yes, Mr.
My lord,
Bose.
may I just say this, my lord?
Yes.
My lord, I am a little handicapped today, my lord. My lord, why the brief is not there. I did not expect the matter to come in like this today. My lord, can I get any day? Can I just any other day, Monday, Tuesday, any day convenient, my lord?
Well, Monday, not Tuesday. Tuesday, I'll be already booked.
Next Friday,
Next Friday, very well.
27.
My lord, I don't want to embarrass, my lord. Next Friday, my lord, 27th. Very well, man. Next Friday. Grateful.
As per
The great.
suffering for the petitioner, so and so suffering for the alleged contemptor. No, contemptor is over. That is
Yes,
on
contempt application.
so suffering for
No,
the
contempt is over, my lord. Contempt is over.
Is not there.
for the plaintiff, so
The defendant and plaintiff.
suffering for the plaintiff, so suffering for the defendant's number.
One.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 27th under the same heading.
Deeply obliged.
Item number 10, Lordship, I am for this petitioner and Mr.
Item number 10.
Item,
What is the application?
Well, I'll just tell you, lordship. But on one ground, they have agreed to appear in this matter. That my learned friend, nobody will open their mouth. Correction. Well, they will hand over to your lordship a copy of the order of 21st of March 2024.
Yes, it is there.
Yes, well, there I have personally made well 2 typographical error correction well that your lordship will see, which is in the set out portion at internal page 2. The set out portion of the order of 22nd June, well, your lordship will see handmade pencil corrections are there.
Yes.
And at page 3. Well, these are the only 2 corrections. Well, department is not. There's a letter of administration which your lordship has order has been passed. Department is that. This is all we need to travel your lordship. Nothing else.
For the petitioner, the petitioner has filed the present application being GA 4 of 2025 for correction in the order dated 21st of March 2024. Counsel for the petitioner submit that in the order dated 21st of March 2024, in page number 2, paragraph 4, line number 6, the word and inward comma and the the is to be deleted, and after the word daughter, the words and husband inward comma is to be incorporated. The counsel for the petitioner further submit that in page number 3 of the said order at paragraph 4, the word petitioner shall be read as petitioners. Had the learned counsel for the petitioner peruse the application and the order dated 21st of March 2025. In the order dated 21st of March 2025, 21st of March 2024, in paragraph 5, line number 6, the line said be read as this, read as inward comma the son, comma daughter, and the husband have filed the present application for grant of and come across. Simultaneously, in the page number 3, fourth paragraph, the word shall be read as petitioners instead of petitioner. This order may be incorporated with the order dated 21st of March 2024. GA number 4 of 2025 disposed.
Deeply obliged. Obliged. Deeply.
So this matter, my lord, has become, lord,
This is my application, your lordship, my lord.
complete abuse of the process of law. Repeatedly, 3 my lord, applications of your lordship's order my lord,
Second
to be
application, your
recalled.
lordship.
What is the application for?
My lord, I am seeking recalling of your lordship's order, my lord.
What has done this court?
No, no, my lord. Just due to mistake of my client's advocate, my lord, I will say, GA2 was filed for revocation and recalling, my lord, of the probate which was granted, my lord. There is a very fit case there, my lord, that the name of the mother-in-law and daughter-in-law, the daughter-in-law is my client, my lord. The name is the same. The citation was received by Anjali Kanungo, which is the name of the mother-in-law. And my client's name is Anjali Saha, my lord, which is the name of the daughter-in-law, my lord. My lord,
Anjali Kanungo is?
the mother-in-law. And the father-in-law's will is being probated, my lord. That was allowed. We filed a revocation, my lord. My lord was pleased to grant us some time to sit for the parties to try and settle, which failed, my lord. Then the matter came up for hearing. The advocate for the applicant, my lord, was not present that day. Then it came upon one more day, my lord, that day as well. And your lordship was pleased, my lord, to dismiss the application for default, my lord. Then a recalling application was filed, which is GA3, my lord. On that day as well, my lord heard the matter and my lord was pleased to allow the recalling application and GA2 was restored, my lord, upon imposition of cost of rupees 10,000 rupees to be paid within 7 days from the date of the order, my lord. My lord, humbly I am submitting, there is very less for me to say, my lord. I am seeking your lordship's compassion in this matter, my lord. 7 days time was granted. I don't know. I was not there in the matter, my lord. The amount was given, but somehow it was not 1 day late, 2 days late. The amount in cash reached to my learned senior friend's client, my lord, the advocate on record. My lord, due to this, your lordship was pleased to dismiss.
So the money never reached us.
Your lordship has recorded, my lord, that 2 days later, the amount was paid, but my learned senior friend's lawyer, my lord, on page number 9, your lordship may direct your lordship's kind attention, my lord, March 12, 2025 order.
Correct.
Your lordship on page number 10. The counsel for the applicant submits that the applicant has approached the executrix, but they have not accepted the said amount. The court was pleased to pass an order dated 26 February 2025, given 1 week's time to the applicant to pay the cost from date. 1 week was over, but the amount was approached on 7th March, my lord. My lord, I humbly state, my lord, there's very less for me to say in this matter, my lord. 2 days late was their very critical view, my lord, of the order was taken, my lord. This is a fit case, my lord, where GA2, if your lordship hears, my lord, if it comes on board, my lord will see there is fit case, my lord, for revocation of the grant of probate, my lord. The client is suffering, my lord. I'm seeking your lordship.
But when the court has passed an order, conditional orders passed, pay the 10,000 rupees cost. When the case is called subsequently after the 1 week, you have not paid the cost. What can be done?
My lord sees, I saw the video of that date, my lord. The learned advocate got cash in court and was giving, at least a DD was to be made and given so that the court, my lord, there was some difficulty here, my lord. I humbly pray.
That's why I'm telling you made the witness, court as a witness to the transaction
No,
between
my
the
lord.
parties.
My lord, the client should not
The
suffer, my
court.
lord. She's there in court, my lord. Unnecessary is being harassed, my lord. I'm humbly praying, my lord. One last
How
opportunity.
this recalling application is maintainable, I do not know, my lord. They were represented, they made their submission, the submission was taken into consideration.
My lord, here there's very less for me to say, my lord. My lord will kindly allow this, my lord. My lord will kindly allow this one opportunity, my lord. My lord, I'm seeking one opportunity before your lordship. If your lordship kindly allows me.
I can. You show me what ground.
My lord, the amount was given 2 days late, my lord. Only this was also there was
considered by my lord.
by
Submissions were considered and disposed of.
Yeah,
The
the
fault of the
applicant has approached the executive 7 months, but they did not. This court passed an order on 26, given 1 week time, the applicant to pay the cost. 1 week time was over, but the applicant has not paid the amount, and this court passed an order on 12th of March. Then
your lordship. That is before your lordship, my lord.
And earlier order was on 28th of
It's
By
not the
which
next
order
week.
the
Your
cost was
lordship.
imposed?
Your
The
lordship.
26th of February, my lord, the last order
26th of
was
Feb.
passed.
Page number
Prior
14,
to
your
that,
lordship.
22nd of January.
Then
Prior
Page
to
number
that,
14,
5th
your
of January.
Your lordship sees how there was
Your lordship,
some
because this matter is such a
error
matter
on
for.
part of
Yes.
Lord, I am also
Well,
told,
kindly.
my lord, the rooms, my lord, under her possession has been kept under lock and key also in a flat. So this is their conduct.
She is a daughter-in-law, my lord. The will has been probated, my lord, without proper notice upon her, my lord. I am seeking your lordship's kind compassion. One
That's correct.
opportunity may
That's
be given,
correct.
my
But
lord.
problem is that under what ground recalling some ground is to be assigned.
My lord, the advocate.
Only on mercy, the mercy has already, you have not given the mercy on that order. So how the situation is changed now?
My lord, just this opportunity before your lordship, if your lordship
Same
kindly
submission was made on that day also.
but still there was some discrepancy, my lord, for which reason the party could not get the amount through, my lord.
What can be done?
Though they had paid the advocate, my lord, which is my instruction, my lord. I have the
These are again, my lord, allegations unsubstantiated, my lord.
Challenge.
But it's very easy
Thank
to
you, my
give
lord.
allegations against advocates.
I understand, but
So,
this is what I have to
Supreme
Yeah,
Court, the
being an
petitioner
advocate, you
says
must
that
not
I-
make that submission. Then
the petitioner has filed the present application praying for
recalling
recalling of the order dated 12th March 2025. This court
Right.
finds that
This is not right.
the
This is not right. This is not right.
this court finds that the petitioner has not paid the cost imposed by this court within a week to the executrix, and as such, this court has reviewed the order dated 22nd of January 2025. Today also, when this case has been taken up for hearing, counsel for the petitioner submit that he may be allowed to pay the cost, submit that he is ready with the cost, and he may be allowed to pay the cost, and the order dated 21st of March 2020, 12th of March 2025 may be recalled. But the counsel for the respondent raised objection and submit that no ground has been made out for recalling of the order dated 12th of March 2025. He submits that this court has categorically passed an order directing the petitioner to pay the cost of rupees 10,000 within a week, but in spite of completion of the week, the petitioner has not paid the said amount. And when the matter was called on 12th of March 2025, this court specifically held that the petitioner has not complied with the order. Accordingly, the order was reviewed. In view of the above, this court did not find any merit in the application. Accordingly, GA4 of 2025 is dismissed.
Obliged.
This is that restitution application, my lord, that Mr. Chaudhary was, my lord.
We had concluded our submission.
We are supposed to rejoin, my lord. Mr. Chaudhary has left court for the day, my lord. He had some.
Any day convenient to my lord.
My lord, we shall not take more than 15 minutes, my lord. Next Friday we'll conclude, my lord.
When this all will dispose of? As per the prayer made by the counsel for the plaintiff.
For the plaintiff. For the plaintiff.
For the defendant.
For the defendant petitioner.
Defendant petitioner. The case is adjourned. Let the matter appear on 4th July.
Yes.
4th July. Great.
Deeply.
I'm for the petitioner in this matter, Your Lordship, led by Miss Chatterjee.
Huh?
I'm led by Miss Chatterjee in this matter.
Who?
Miss Ujjaini Chatterjee. She's on her
Can't
legs.
hear you. Please use this microphone.
She's on her legs before.
Who?
Next slide.
Next slide.
Very sorry, my lord. This matter, my lord, was heard on the last occasion.
7 weeks time.
Huh?
But I will very briefly, my lord, reprise what happened, my lord. This is my suit, my lord, for money lent and not paid. And my lord, we had also filed an application for admission upon judgment. My lord, judgment upon admission, order 12, my lord. And we had, my lord, argued the matter, my lord. I have been briefed subsequently, but my lord, counsels earlier has already argued that application. Affidavits are also complete, my lord. And it was pending for arguments to be commenced by the defendant, lordship. And My lord, if your lordship pleases, my lord, then I can re-argue the matter, my lord. Otherwise, my lord,
That is not here.
my lord, he's the defendant.
I'm on the defendant.
Yes, my lord.
I'm on behalf of the defendant. I'm praying for 70.
But it can be kept on any day for arguments also, my lord. And if lordship pleases, my lord, I can re-argue the matter. Because, my lord, I believe, my lord.
We have to submit.
You are for the defendant.
I am for the.
What is the GA2?
Well, GA2 is my application for
attachment, etc.
No, my lord, GA2 is my application.
GA2, GA8,
8 and
GA9.
GA9. GA8 is GA8 for rejection of the GA2 because that is based on the document which was not affirmed and submitted before the court. So there the GA2 application is on the basis of that wrong written
GA2 is my Order 12 Rule 6 application, my lord.
And GA9 is for the
Supreme for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 11 July.
My lord, can it be fixed, my lord? My lord, it's been
Then
pending.
you have to go to the August. I will fix the date, August.
My lord, first week of August, lordship.
First week, I don't think. After
August
the
is okay with me.
Independence Day only.
My lord, well, it has been pending for long, my lord. So they have to begin their arguments, my lord. Then this application can be disposed of.
Have a date.
Not that application 8 and 9 are also to be disposed.
Yes, but my lord, this is already part third, no? We have completed our
13th
arguments,
August.
sir.
Okay, you got the before Independence Day. 13th
Grateful,
August at
lordship.
12:30.
Grateful, my lord.
12:30 on?
13th August.
13th August. Yes, next.
My lord, I'm for the respondent, my lord. I'll be grateful if my lord takes this matter up on Monday, my lord.
Monday?
Monday, my lord, because I'm.
What time you suggest the time? I will sit.
No, my lord, I'm.
Giving us at 10:30 to 4:30. You tell the time. I will court will sit.
I'm very sorry, my lord. I
will come at 9.
My lord, I'm very
9
sorry.
to 10:30. I will take 4:30 to 6:30. I will take.
My lord, I'm very sorry, my lord. The only reason is, my lord, Mr. Bagh is leading me in this matter, my lord. He has substantially completed his arguments, my lord. Only the judgments are left to be shown. He's on legs today, my lord. That is why I was making.
Everybody on leg. Nobody is without leg.
My lord, only prayer, my lord, I was making is that, my lord, because he had made the substantial arguments, my lord. If the last opportunity could be granted to us, my lord.
Yes.
One last time.
You are appearing for whom?
The respondent, my lord.
Respondent. GA number 1.
Sunil Marwa.
GA1.
GA1.
Security deposit. Security deposit. Sense suffering for the plaintiff, sense suffering for the defendant, counsel for the defendant, prays for time. According the case is adjourned. Let the matter appear on 4th July. Next.
Yes, my lord, I have.
Your Lordship, my application.
Yes.
But I'm for the plaintiff. It's a defendant's application for an order 7 due delivery.
We had
Now,
made
madam.
submissions. The defendant
madam.
respondent had to make submissions, Your Lordship.
We were to give reply to their submissions, Lord. Only one point that is left to be argued is a point of commercial dispute, whether this suit should be a commercial suit or not. That's what they have argued. Now, the Lordship is aware of the Thika point. We have answers. The commercial dispute point we have to answer. Now, the Lordship is aware of the P. Thompson judgment that Lordship had delivered, and the matter went up to the larger bench. The larger bench yesterday, Lord, had delivered the judgment. And the Lordship's view has been ultimately upheld by the larger bench. So, in view of that, all suits which were filed as regular suits following Deepak Polymer judgment is now in difficulty. All those suits. And I was one of the parties in that matter as well.
What is the submission now?
Now, my clients are my clients are we also we are sitting in this weekend to decide the future course of action. There's so many suits will suffer the same fate. Lordship will keep giving me some time. We'll decide on that and that will come back. Maybe we have to withdraw this and file afresh. That is the only outcome left. If the judgment remains, or we have to seek amendment. We have to think of something. But there are we are told there are about 35 suits which are pending and have the same problem.
Let the matter appear on Can I fix the date or on 18th of July?
Yes, yes, sir. The 85 pages long judgment, my lord.
Take instruction, come on that day.
Yes, 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 sir. Grateful.
Yes.
My lord, I'm for the petition. I'm led by Mr. Shakur Sen in this matter. He's out of station, my lord. So if we could get a.
What is the matter?
My lord, if your lordship recalls, a suit for partition, my lord, in which we have filed an application under Order 7, Rule 11 for dismissal of the plaintiff on the twofold ground, my lords, on the point of limitation, as well as on the basis of the facts which has been narrated in the plaint, which will show that the whole cause of action has to be decided by the Company Law Board first, National NCLT first. Then it has to be, my lord, if it is an adjudicated on that issue, then, my lord, is cause of action. So on that basis, my lord.
When?
My lord, short date.
Short date.
There was.
My lord, I believe, my lord, my learned friend is in some difficulty because she's being led by Mr. Sen and I'm also being led by Mr. Bose.
Census and suffering for the plaintiff, census and suffering for the defendant. Let the matter appear as per the prayer made by the counsel for the parties. The case is adjourned. Let the matter. एक date दे. 14th August at 12:30.
At 12.
I am fixing the date so that matter can be.
Great.
My lord, I'm appearing for the plaintiff. Just praying for a short pass on Mr. Banerjee is on his way to the court. Mr. Banerjee is on his way to the court.
Pass हुआ.
Number 18.
18, my lord, I appear for the plaintiff, my lord.
Yes.
This is my application, judgment upon admission, my lord. Lordship may recall, my lord. Mr. Malay Ghosh has argued, my lord. The case is really, my lord. The nephew has sold a joint property of the, it also belongs to the aunt, my lord, without taking her consent, my lord, to an outsider. So, my lord, section 22, my lord, grants a preemptive right, my lord. I have been deprived of that right, my lord. In the written statement also, my lord, there is no mention that consent was taken from me prior to making this sale to a third party, my lord.
Correct.
So this is the case, my lord. We had
For the
completed.
defendant number 1.
Defendant was to argue, my lord. We had completed our.
Is leading in this matter. Mr. Devjit Mukherjee is leading in this matter.
My lord, last occasion I started my argument. My lord, I have placed, my lord, your lordship, my lord, the appeal in opposition. And my lord, last occasion, my lord, I have submitted before lordship if the matter can be settled because the lordship has already heard the matter. The only thing is that whether the notice has been given, my lord, before purchasing the property, I am the outsider, one of the co-sharer transfer the property. Now, my lord, if lordship be kind enough to my lord, give another 15 days time, my lord, so that my lord, it can be.
Say this, my lord, there was a chance, my lord, they had given an offer, my lord. We gave a counter offer, my lord, way back in 9th of April 2025, my lord.
My lord, counter offer they have given, my lord. We are discussing with the client, my lord, because the counter offer which they have given, my lord, there is too low, my lord. That's why we are trying to, my lord, ascertain with them, my lord.
Defendant.
Because it will be settled, my lord, for once for all, my lord.
Defendant. Case is adjourned. Give the date. Let the matter appear on 18th August at 12:30.
Yes, sir.
August 12:30. Come ready.
Yes.
Yes, sir.
Next. 18th August 12:30 fixed for but settlement time changes.
I am fixed the date so that you can come complete the matter. $19. Nobody.
For the plaintiff petition, my lord.
Yes.
Hearing of injunction application, affidavits have been complete.
What about the interim order?
The interim order is still 18th of July. 25th of July, I'm sorry. 25th of July.
Which was the defendant?
Mr. Snehal Kakrania was appearing on behalf of the defendants. It's that defamation matter where my lord had passed orders in connection with the premises.
Pleading completed.
Pleading completed.
Let the fix for hearing.
Yes.
So suffering for the plaintiffs. None appears on behalf of the defendant. It is submitted that the pleadings in connection with GA1 of 2024 is completed and is ready for hearing. In view of the above, let the matter appear. Give the date. 19th August, 12:30.
The interim order is still
Next month.
next. No, August বলছে।
When interim order is
25th
going?
of July.
25th of July.
Yes.
You mention that I will extend.
But I appear on behalf of the respondent.
Yes.
But we have our order 7 rule 11. We have the order 7 rule 11 out here. Your lordship, my lord, they had taken an ex parte ad interim order from your lordship. Then your lordship, upon hearing, my lord, had vacated the order. My lord, we have also taken out a 711. And my lord, they have preferred an appeal against that. My lord, that they have not moved and they're not moving also.
Okay. That shares
That
of
clause, that interpretation. If your
what is
lordship
happening in the appeal?
Nothing, they're not taken any steps.
Item 20, my lord. The appeal is fixed on.
My lord, it's not
running in the list. Maybe taken up on Monday.
Lord, kindly record this that they want an adjournment on this.
GA1 is with regard to interim order.
Yes.
And GA3, GA4.
My lord, we have a matter demerral. I want to move that. I want to move that demerral.
Both defendants are all separate.
Yes.
Yes, my lord.
3 and 1 and 2 and 3 and 4.
I'm led by Mr. Abhijit Mitra, my lord. He has not come to court today.
My lord, there are other people also. My lord, there is Mr. Chaudhary also.
So I am fixing a date. In the meantime, in the appeal.
The only thing is kindly record that they are seeking an adjournment on the ground that the appeal is filed.
And with regard to the other J3 and 4 pleadings completed?
Yes, all can be heard out.
Sense appearing for the plaintiff, sense appearing for the defendant. You are appearing for the defendant number 2 and 3?
2 and 3.
What about the 1? 1. Sense appearing for the 1. It is submit. Counsel for the plaintiff submit that the appeal is pending before the appellate court, and the appeal is in the list and placed for adjournment. Counsel for the defendant submit that reading in connection with all the interlocutory application has been completed and is ready for hearing. In view of the above, let the matter give the date. 2 dates. Give 2 dates.
Let kindly record their objection. That yes.
Objection.
Yes.
28th August. 20 August and or
2-year adjournment.
20th August.
2-year adjournment.
20 and 21st of August 2025 at 12:30.
Grateful to you.
Come ready. Next.
My lord, I appear for the defendant in this matter. I appear for the plaintiff in this matter, and the demurrer application which is pending, your lordship had heard it to a substantial extent. Mr. Ray, who was leading,
Lordship recalls Mr. Ray was leading me in this.
my learned friend, Mr. Ray was leading. So he had made his submissions, and we had also made our submissions in response. However,
Section 8.
Yes, it's a Section 8 question of whether the court retains jurisdiction or it gets referred to arbitration.
Correct.
So, your lordship, some cases were being cited by them. They had relied on one judgment, the re-interplay of arbitration agreement, the 7-bench judgment of NN Global. They had started showing it and the matter was adjourned. So once they conclude, your lordship, we have no difficulty. We can conclude our submission.
Sense suffering for the plaintiff. Sense suffering for the defendant. As per the prayer made by the counsel for the defendant. Case is adjourned. Let the matter appear on.
My lord, just had a prayer. If it pleases the lordship, could your lordship fix up a time because this matter has been going on.
22nd August 2025 at 12:30.
Very grateful, your lordship.
Industry.
My lord, in this matter, I'm led by Mr. Prabal Kumar Mukherjee, my lord. It will take some time for him to come, my lord. We are ready for the.
I don't know how many times the matter will be adjourned.
It's not been adjourned, my lord. Kindly passes over. He's on his leggings in another court, my lord. It's 3:30. I know, my lord. All of a sudden, the matter has been called on.
There is a power of attorney issue, my lord. Your lordship had been.
My lord, kindly fixes a date and time, my lord.
We have, my lord, finished our arguments long back. 6 months back, my lord, we have finished our arguments.
एक कोई डेट है 2 डेट देखो खत्म कर देंगे इसको इससे पहले कोई डेट नहीं है, बहुत पुराना मैटर है। How far this court can go, I don't know.
I realize, my lord, I am amazed as to how your lordship is, my lord, tackling these matters.
ठीक है, वो अगस्त में दे दो, 2 डेट दे दो, 25th 26th August. Sure, otherwise I will close the matter
My lord, my lord.
at
August.
12:30.
Very well.
My lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. Counsel for the defendant prays for time. Accordingly, case is adjourned. Let the matter appear on 25th of August and 26th of August at 12:30
My lord.
as a specially fixed matter.
Well,
I know.
next matter, my lord, same order.
Both. 22 and 21 and 22 दोनों एक साथ रख दो.
Your lordship need not, my lord, record any direction, but my lord, let it be understood. If don't argue, my lord, then the argument will be.
That's why I'm telling. Inform her.
My lord, we were present, my lord, sometime.
Come on that day. That's why
My
I fix a
lord,
specific
my
date.
lord, grateful, my lord.
2 months, 3 months before, 2 months before I given the date, so you can reserve that date.
My lord.
Yes, next.
Your Lordship, I'm praying for not today. I'm being led by Mr. Abhijit Mitra and Mr. Anuj Singh.
Lordship, I appear for the defendant. Lordship.
We were in reply to the GA.
What is the matter?
Lordship, this is a rejection of plaint, Lordship. We have filed a rejection of plaint. We have concluded our submissions.
We were in reply, Your Lordship.
So and so appearing for the plaintiff, so and so appearing for the defendant. You are for the defendant.
Lordship, I for the.
As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter 3:40 के बीच में था ना कोई एक टाइम दे दो. एट ऑफ जुलाई नहीं रहेगा, 14 जुलाई में है, 14 15 कुछ भी नहीं तो नेक्स्ट तो क्या अगस्त में है या अगस्त में कब है? हाँ नहीं, नॉर्मल टाइम में 27th of August at 12:30. Yes.
My lord, I am Milad Toraria. I have filed writ petition being diary number 32476.
For defendant number 2.
25 before the Supreme Court.
Yes. What has happened in the Supreme Court, sir?
Huh?
What has happened in the Supreme Court? You filed the appeal.
I filed during vacation. So it is listed only after vacation. And it will take at least 2 months' time.
But you have sent one letter to this court on 20 December 2024 stating that my SLP was dismissed by the Honorable Supreme Court by observing that in my SLP there is no grievances against the Honorable Court, rather is against the manipulations adopted by the plaintiff through his advocate. As such, I filed the aforesaid application under 151. I again tendering So where is your application under section 151?
This is with you, Your Lordship. 151 is with you.
151 application है क्या?
My lord, it is the application filed by my learned friend is not affirmed before the oath commissioner.
What is the application number, sir, Mr. Chamaraya?
I am not aware because your lordship has not allowed me to file. If I go to Calcutta, I will be killed. That is the point. That is my point. They are ready to kill me.
No, nobody will kill you. You stated.
Yes, I already suffered an attempt to murder.
Okay, Mr. Choraria, you can only use SIM and tell me what is your application number? What is your application number so that the application can be taken up for hearing, sir?
My lord, I have filed the writ petition in the Supreme Court with regard to all the matters, referring that mandamus or the other writ petition, writ order or direction that it is prima facie indicated that respondent number 1, that is the plaintiff here, is a land mafia and is criminally engaged to grab public and private properties.
Now today what you want?
I want to adjournment, 2 months' time.
Yes, Mrs. Agrawal, you are appearing for the plaintiff.
Yes, my lord, I am appearing for the plaintiff. Your
She
lordship
is a
see.
manipulator. She is not a liar. She is a manipulator.
Mr. Chararia, please, I have heard you. Let me hear Miss Agrawal. Yes.
My lord, no such application is on record. What my learned friend does, my lord, he sends the application, my lord, from there. What I respectfully submit, whatever he submits, my lord, I do not take on heart because he does not understand what he is submitting. But what I'm saying that let him engage a lawyer, let him affirm an application in Delhi.
My lord, I have appointed large number of advocates and barristers. Every barrister and advocate has been impressed by them. How I can appoint any advocate?
He submits that he has filed.
Including Gopal Subramaniam. Gopal Subramaniam was impressed. Barrister impressed.
And he
my lord, may I make one submission, my lord? For last 2 years, my lord, he has filed a GA number 4 before this honorable court, my lord, inter alia alleging that the summons of the suit have not been served in accordance with the original site rules. Now, my lord, in this regard, my lord, we have already filed an affidavit before this honorable court pursuant to the direction of the coordinate bench of this honorable court, inter alia disclosing the manner in which the summons of the suits have been served pursuant to the leave granted.
Till today not served. Someone not served. It is false.
And in the GF4, the pleadings have been completed?
GF4 pleading has been completed. Kindly take up the matter any date, my lord, or my lord, if
my lord, the affidavit in reply objection filed by the one employee who cannot file the affidavit in reply objection.
Learned counsel for the plaintiff submit that the the defendant number 1 has filed an application being GA4 of 2022 and the pleadings have been completed and separate for fixing the matter for hearing of GA4 of 2022. In view of the submission made by the counsel for the respective parties, this court find that the defendant number 1 has filed an application being GA4 of 2022. Let the same be fixed for hearing. Let the same be fixed for hearing on 18th of July 2020.
My lord cannot hear this petition because I have made objection in the Supreme Court against their filing objection. I have made objection against their objection because objection has been filed by an employee who cannot file the affidavit.
Okay, you get an order. I am fixing on 18th. What will happen if
what 18th?
I am fixing on 18th of July. Let it come on 18th July. Yes.
My lord, I have also submitted that I cannot get justice.
Okay, come on 18th. If your SIP is not taken, then we'll see to that what orders to be passed.
My lord, 25 on the plaintiff in this matter. I'm praying for an adjournment today. Kindly, my lord, takes this in the next week.
Yeah. स्पेशल असाइन मैटर है हाँ कौन सा आइटम नंबर yes
my lord I'm praying for an adjournment today.
What is the tier 2
my lord it is for restoration of restoration of the suit my lord. My lord, Mr. Rudraman Bhattacharya is appearing in this matter. Is
restoration application also you want senior now?
My lord, kindly grants me a week's time, my lord, or any day in this week, my lord.
As per the so-and-so offering for the petition plaintiff, as per prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 4th of July. Next.
I appear for the respondent, my lord, in this matter.
But I am for the plaintiff. My application for judgment upon admission, which my lord has been defended at length. I am at a stage of reply. But I was being led by Mr. Dutt. If it can stand over to next Friday, we will be in a position to complete it, my lord.
This is that money going round, my lord, the circular transaction matter. This is the matter is going round in your lordship's court now.
Along with your money.
No, along with our money. We are the plaintiff.
My money in your pocket.
So-and-so offering for the plaintiff, so-and-so offering for the defendant. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 4th July.
Deep law applies.
So is the lordship's pleasure to fix a time, then it can.
Then it will go to the last.
No,
week
no,
of
then let it.
August.
But let it be.
I will
Not
fix.
he'll be able to complete.
Your lordship will reach nowadays.
Mr. Dutt is there. He'll be completing it.
Friday.
Deep law.
Next.
Oh, Friday.
I pay for the plaintiff. We have filed an application for substitution. That is GA4. On the last occasion, the defendant number 1 said that they will file an opposition. Lordship, till date, that opposition has not come.
I am appearing on behalf of the intervener, my lord.
With respect to the intervener,
And that has been allowed, my lord.
that has not been allowed. Lordship will feel the last order, para 10. This court is of the view that GA2 and GA4 be taken up together for hearing. So it has not been allowed.
Milord,
Submitted
in
by
para
my
7,
learned
Milord, it has been stated.
Lordship, I have said
Counsel for the
Objection for allowing the application.
yes, I have
while
said
the
that I have
examiner
no
being
objection,
without prejudice
but
to the right and
I
contention
cannot
of the plaintiff.
keep on amending.
That's why I kept the both
Yes.
at a hearing.
Lordship,
So,
but
where
the
is
opposition,
the affidavit? Who is the for the other side?
the defendant number 1 is the main person, Lordship, who sought for time on the last occasion.
Surajit Das Gupta.
Surajit কোথায়?
Sense offering for the plaintiff. Sense offering for the intervener. None appears on behalf of the defendant number 1. For the interest of justice, the case is adjourned. Let the matter appear on 11th of July. Yeah, वो matter भेजो. Fix में हुआ है ना? नया matter. Fix नहीं हो जो.
I'm grateful.
Grateful, my lord.
My lord will allow Mr. Alim to present the plaintiff.
Lord, I'll present.
Yes.
But may I have my lords kindly, my lord, to present a plaint.
What is the suit for?
Suit for declaration and my lord permanent injunction against the defendants, restraining my lord the plaintiff from carrying out its duties. My lord, the part cause of action has arisen within and part cause of action has arisen outside, as pleaded in paragraph 15. Hence, my lord, leave under clause 12 I have sought. And my lord, I have also sought for leave under order to rule 2 because I have reserved my right to claim damages. The plaintiff as well as defendants are both outside, and my lord, no part of cause of action is barred by the laws of limitation. (15) and 16, my lord.
Sense offering for the plaintiff. The plaintiff has filed the present suit for declaration, declaring that the defendant number 1 and 5. Suit for plaintiff has filed this suit for declaration and other and consequence and other reliefs. Police counsel for the plaintiff submitted part cause of action arose within jurisdiction of this court and part cause of action arose outside the jurisdiction of that court. Accordingly, prays for leave under clause 12 of the latest petition. Counsel for the plaintiff also prays for leave under order to rule 2 of the CPC on the ground that the plaintiff is unable to quantify the actual loss suffered by the plaintiff, and as such there is chance that in future the plaintiff made a further claim of damages. In view, consider the submission made by the counsel for the plaintiff, peruse the plaint and the materials on record, leave under clause 12 of the latest patent as well as order to rule 2 of the CPC is granted. Plaint is admitted subject to scrutiny by the
My lord, may kindly permit Mr. Ghosh to.
May it please, my lord. And the plaintiff is a pharmaceutical company. Your lordship knows that the medical and sales representatives have to go all around West Bengal to promote our sales, to the doctors and to hospitals, etc. But in August 22, one such representative had been terminated. The proceedings are pending before the industrial tribunal, my lord. Now, from last year, July, the union, the defendants 1 and 5, my lord, they have tried to take up cudgels for this particular person, and they have been disturbing and preventing our representatives from visiting or carrying out their duties. Numerous police complaints. Finally, in April we approached the writ court for police inaction. We got orders also, Despite that, they are saying those orders are binding on the police, not us. Despite that, they've continued to harass and criminally intimidate us. We've given a list at page 16 of the petition, of the complaints that we've been having to file. And in fact, after filing the suit also, 3 more complaints we were constrained to file, which I want to bring on by...
the complaint filed by you?
Yes, these are complaints filed by us against all these actions that we've been taken. If my lord only comes to one paragraph, paragraph 22, I might just place that, my lord, that's the case. The respondents and their members on the ground of the transfer and termination of an ex-employee of the plaintiff are purporting to organize various protests throughout Kolkata and parts of West Bengal with the ulterior and malafide motive of preventing the petitioner from carrying out its duties. The respondent has no locus standi, my lord, it's not a recognized union also, or to try to take up cudgels against the petitioner using force and committing various criminal activities, etc. My lord, I am really emboldened to move this ex parte. Your lordship had passed a very absolutely similar order in another matter, which related to another health company, of course. But the same defendant is defendant 5 in our case, and their West Bengal unit is defendant number 1. Well, the identical things are happening. We have filed, we have annexed all the complaints, and the last 3 complaints are by way of the supplementary affidavit. So at present, I'm asking for prayer A. A should suffice, but prayer E is more elaborate because it talks about the real damage we are facing, my lord, is that our field workers are not being able to work. A and E. Then we shall serve them, my lord. We have not served them in view of this urgency. Their attitude seems to be that you have got an order against the police, not us.
Yes.
And it's continuing.
Yes.
That this order, I believe, is still subsisting, the order in Abbott. This was, of course, the ad infinitum stage. I'm praying for a similar order with the directions to serve them and come back.
That's all?
Yes. At present, that's all.
The petitioner has filed the present application for grant of ad infinitum injunction. The petitioner is aggrieved about the wrongful actions of the respondents through their members and agents who are some ulterior motive have initiated a series of unlawful activities against the petitioners and its employees. Petitioner submits that substantial market shares and long-standing presence in the industry, the petitioner is recognized as one of the leading companies in the pharmaceutical sector, and over the past 2 decades, it has established a strong operational base and cultivated significant goodwill among medical practitioners, hospitals, laboratories, chemists, distributors, and retailers throughout the West of Bengal and state of West Bengal. Then for the petitioner submitted. Success of the business of the petitioner is substantially dependent on the effective reach of its field sales representatives for the purpose of advocating, informing, and introducing doctors and medical health care professionals about the latest trend and medicines and the products being manufactured by the petitioners. As such, the said field sales operation are crucial and vital for the petitioner. Vital part of the petitioner's survival. Vital part of the petitioner's survival. It is submitted that On 24th of July 2024, a systematic attempt has been made to disturb the business of the petitioner by persons claiming to be affiliated with the defendants by physically assaulting and unlawfully obstructing the employees of the petitioner from discharging their official duty. Police. In several instances, such employees have also been sustained grievous injuries. These acts have been willfully perpetrated by the individuals identifying themselves as members and office bearers of the defendants, allegedly acting in protest against the termination of service of one Siladatya Chatterjee. Number next. Counsel for the petitioner submit that the said termination was carried out by the petitioner strictly in accordance with the law after following the due process and on the ground of serious misconduct including gross insubordination and physical assault upon the senior officers of the petitioner company. Counsel for the petitioner submitted that due to the business exigencies, operational organizations, and optional deployment of human resources, a bona fide decision was taken by the management of the petitioner to transfer the ex-employee from Tamluk headquarters, which falls under the Kolkata Administrative Office of the plaintiffs, to Jaipur headquarters. The decision was duly communicated to the ex-employee on 6th of July 2022, which clearly set out the terms of reopening instruction, whereby the ex-employee was directed to report to the district sales manager Jaipur for functional supervision. Counsel for the petition submitted that the union is neither recognized under any scheme nor as it has been accorded by any official status of or recognition by the plaintiff. He submits that union has no locus standi to interfere with the internal administrative and business decision of the petitioner. He submits that it is the prerogative of transfer and deployment of the employee lies exclusively with the management, specifically in private organization, subject to the terms and conditions of the employment of contract. Counsel for the petition submit that. There is your complaint.
The complaints are from page 85 to 106 are the complaints within jurisdiction, and from 107 onwards, my lord,
for the petition,
and the last three are the supplementary.
Petition has lodged multiple complaints with the various police authorities.
Page 16 they are set out.
Police authorities across the state of West Bengal, including Posta Police Station, Harmless Police Station, and New Market Police Station. We submit that despite filing of the repeated detailed comprehensive complaint and making several representations from the police authorities are not taking any action, due to which the petitioners are facing great difficulties. Counsel for the petitioner submitted, since the law enforcement mechanism failed to act with the urgency and efficiency, the petitioners have compelled to file to invoke the writ jurisdiction and file on what order was passed in the writ application?
The writ 17th of April, page 83, man. Police was directed to see that they are not hindered.
The Honorable and the coordinate bench of this court has passed an order directing the police authorities to ensure on receipt of the complaint that any manner or the other representative of the agents of the respondent company are not hindered from any carrying out from any day-to-day activities in regular course of business. Counsel for the petition submitted, in spite of the order passed by the High Court, the police authorities not taken any steps, and the respondents are invading and threatening to invade the petitioner's right to carry on its business in the West Bengal. Counsel for the petition submitted, there is an urgency to counsel for the petition submitted unless and until an interim order is not passed by restraining the respondents from interfering. Respondents, their men and agents for running the business of the petitioner and its employee in Kolkata throughout the state of West Bengal, the petitioner will be badly prejudiced. At the London counsel for the petition submitted similar situation. Earlier also the similar situation was arose and the petitioners have filed an application. Petitioner have filed a suit before this court. And who is the Abbott Healthcare other company?
That is a different judge. Abbott is different.
Other
We are
companies
Glenmark.
have filed a civil suit before this court, and this court has passed an ad interim order restraining the defendants for interfering with the work of the petitioner. At the London counsel for the respective parties peruse the materials on record. This court find that the petitioner has filed the present suit against the wrongful action of the respondents and their members and agents who are unlawfully restraining the petitioner and employees to perform their work smoothly. It is found that the petitioners have made several complaints to the different police authorities, but till date the police authorities have not taken any action. The petitioner also filed a writ application before the High Court, and the High Court has also passed a direction upon the police authority for taking appropriate steps. But in spite of the same, the respondents are harassing the petitioners, not allowing the petitioners to perform their work smoothly, due to which the petitioner is facing difficulties. But in view of the above, this court find that the petitioner have made out a FSA case and balance the convenience and inconvenience in favor of the petitioner, and at this stage an identity order is not granted, the petitioner will suffer irreparable loss and injury. In view of the above, prayer A and E of the present application is allowed. Full stop. The petition is directed to serve the copy of the print along with the application
And the supplementary.
along with a copy of the plain, documents, the present application, its document and the supplementary affidavit to the defendants immediately, and to file affidavit of service on the net date fix. The interim order shall continue till 23rd of July 2025. Please the matter on 23rd of July 2025. Yes. Who is for the other side?
Well, my advocate on record, my lord, tried his best to communicate.
You are appearing?
Well, he is with me, my lord.
Yes.
Now, my lord, one Mr. Ganguly used to appear on the other days. Well, he is not receiving the phone as I am told. I even, my lord, had, but his clerk said, my lord, he is not there. Now, so far as the advocate for the other sister is concerned, my lord.
He is also not here. What is the which matter?
38, 39. The other side of the advocate was present there. He was informed.
39 na? Oh, 345 kab tha? Ali?
He was eventually present, my lord, even 2 minutes back. He was
July
waiting for this matter.
28 and 29 July 345. 28 and 29 July 345. Inform the other side.
But only for the purpose of filing report. It may not take more than 5
But
minutes.
other side is not here.
Well,
How?
kindly keep it in the next Friday at 2 p.m.
Okay, let then this matter be fixed, not next Friday, on 4th July at top.
The Lordship, 4th.
4th July at the top.
But the 4th July may it be marked at 2 p.m.
That's why 2 p.m. only.
May it be marked at 2 p.m.
2 p.m.
38, 39.
2 p.m. at the top, because
At-
I am taking the non-commercial matter on Friday. So 2
Exactly.
p.m. your matter will be top.
My lord, 4th July.
My lord, regarding my lord, item number 36 and 37, my lord, Ojha's matter, we mentioned it yesterday. Your lordship asked us to watch the list today. My lord, one thing is that as your lordship is taking it only on Friday, may we request, my lord, both sides, my lord, may we request if the matter could be fixed on 11th of July or Friday, my lord, at 2 p.m. Subject to your lordship's convenience. My
PM
lord, a
will be
long gap, my lord, is there. 11th of July.
2 p.m. would
I'm
be
not
required because Mr. Sen would complete, then we will possibly rejoin.
They will reply, yes.
So because only on Fridays, that is why.
হবে 11 July 2 p.m. দেখো না
कोई date है?
3 p.m.
कब? कितना बजे? Monday 11:30.
This Monday 11:30, very well.
Very good.
Yes. Party will come. Then we'll
Yes,
say
yes,
we are
yes.
not
No, no.
aware of that.
No, absolutely.
Absolutely.
madam. All the sides are here.
Record 36, 37.
Yes.
Since the sense appearing for the you are appearing for the
My lord, I am appearing for the respondent number 2 and 4.
2 and 4. You are
Review applicant plaintiff.
since the sense appearing for the review applicant / plaintiff. With the consent of both the parties, let the matter appear on 23rd June at 11:30.
Deeply obliged, your lord.
Very grateful.
Deeply obliged.